Jetzt mit Video.
Wunderbar. Good afternoon to everybody. Permit me to welcome our distinguished speakers to this conference on the Digital Market Act. As you know, we will have an open panel discussion, which will certainly exchange the views which the addressees of the Commission's proposal on a Digital Market Act developed, but we will hear the Commission's explications or explanations on what is planned and the reasoning for it. We will hear our Federal Cartels Office view, also with the competencies between the two bodies, which will have to look after the digital market players and the competition between them. And we will hear distinguished speakers from universities as well as from the industry. So I'm very grateful that we had been able to invite you to this session of this afternoon. I'm very grateful in the name of the German Bar Association and of course of the Committee for European and International Matters, which I'm chairing. Thank you to everybody also who made that possible. And just let us start. I will just introduce our moderator, Mr. Hendrik Kafsak from the Frankfurter Allgemeine, who is a journalist who in the past quite intensively was treating the issue and who will be the one guiding this session. Thank you very much. So hello to everybody who is listening as well, and I hope you will be interested and enjoy this session. Thank you.
Thank you, Ms. Seidel. I see that my virtual background seems to be frozen. I'll just try to switch it off, otherwise it will be a little bit, and that's the good old problem we always have once we try to do something online. Well, I just try to get into the frame then, and we'll start with congratulating the German Bar Association for the perfect timing of this event. We've heard Francis Hogan testifying in the European Parliament yesterday. We have the COREPER, the member states agreeing probably on its position on the DMA tomorrow already. So it's indeed a perfect day to discuss the DMA. Frances Hogan, of course, was testifying mainly about the DSA, but she said it's going to be or could be the gold standard for regulation of big tech and inspire other countries, including her own, as she said, meaning the United States. So in a way, she set the scene for this event today. We have two parts. The one that is the more difficult for most of the ones listening, because that's what they can do, only listen, only in quotation marks, to what our eminent speakers have to say. And we have 9 of them, so quite a few. And afterwards, I want to have a debate that is as open as possible, meaning if you have questions, just post them in the chat and I'll try to include them as interactively, if that's a word, as possible. We have first the Commission, as Ms. Seidel said, then afterwards the German Federal Competition Office and the US side, and then in alphabetical order, and that's why I'm mentioning it, Facebook and Meta wouldn't have changed anything because afterwards we are going to hear Microsoft and Shopify, then the Academica, and last but certainly not least, the rapporteur from the European Parliament, Andreas Schwab. I'll stop here. We're running on a tight schedule, so I'll make sure that everybody just sticks to the 10 minutes he or she has, and we'll start with Inge Bernards, who's only dialing in by phone because they have a power shortage in their street or some other problem as far as I'm informed, and she will tell us how it all began sometime last year, the 15th of December, if I remember it correctly, where the DMA came from and what it's going to deliver or supposed to be delivering. Inge Bernhards, Director of Policy and Strategy from the DG Competition in the European Commission, you have the word.
Thank you very much for that. And apart from the technical disclaimer, which you already kindly brought in on my behalf, I'd also like to start with a content disclaimer that I'll be speaking in a personal capacity today, and views that I express reflect not necessarily the official position of the Commission. Secondly, also you referred to the quite timely nature of this debate, but hence also the sensitivity from my perspective. So I hope you'll understand I won't comment on the ongoing negotiations, but I'll concentrate on the Commission proposal instead, in order to kick off indeed this debate today. And I'll be carefully listening also to what my co-panelists have to say and what participants have to contribute on this issue. Now, what I'd like to focus on is the following two questions. First, why the DMA? And secondly, what are its key features? And how does the DMA interact with competition law? Let me start by why the DMA. Well, when the Commission in summer last year, summer 2020, launched a public consultation on a possible EU-wide regulatory framework for large digital platforms in the EU, this could hardly have come to as any surprise, I think, because the debate on how to control the power of big tech, both their economic power and their societal power, was neither new, nor was the EU the only jurisdiction participating in the debate. The debate was actually, and still very much is alive, also at the other side of the Atlantic in the US. I'm thinking, amongst others, of work done by Lina Khan before she was appointed to chair the FTC. But also in Australia, in Japan, and to some extent even in China. Closer to home, the European Parliament had raised the need to regulate large platforms in several reports. The UK had set up a digital markets unit in the CMA with the task to look into possible solutions complementing the existing competition rules. And in Germany, of course, Article 19A was added to the competition law. So we were not alone. There was a large degree of consensus, I think, across the globe on the problem analysis and the need to act. We were not alone, but nor did we start from scratch. At the Commission and DG Competition, we had by then almost 20 years of experience in very actively enforcing the EU competition rules in the digital sector. And what we saw, not only in our enforcement practice, but also from some reports, most notably a special advisor report that EVP Vestager commissioned back in 2019. What we saw is that the digital sector has some very particular features: extreme scale and network effects, the vast and growing importance of data, lock-in effects and consumer biases. And whilst some of these features are present also in other sectors of the economy, in combinations, these features make the sector prone to winner-takes-all situations. And in such winner-takes-all situations, business users and consumers pay the price. They have less choice and cannot reap the full benefits of a well-functioning single digital market. In other words, it had become more and more obvious to us as policymakers that normal market processes are incapable of always ensuring fair economic outcomes in the sector. And whilst competition enforcement had been effective in remedying some issues, the scope of Article 102 of the Treaty on the Functioning of the EU is limited. And in addition, its case-by-case approach, laying out and analyzing afresh in every single case, not only the definition of markets and finding of dominance, but also the effects and possible efficiencies of certain behavior, make and that is why we opted for a regulatory initiative, not to replace competition law, but to complement it. The Digital Markets Act. And let me briefly highlight what are its main features and in doing so, precisely also on the interplay between the Digital Markets Act and competition law. First, it's important to underline that the DMA creates a single
Ms. Barretts, I'm afraid we have a problem with the sound. We cannot hear you anymore.
Does this work again?
It's now it seems to be working. Just go ahead and we'll see what we can hear or not. Yeah.
It creates a single European-wide regulatory framework. And in that sense, it aims to contribute to the proper functioning of an internal market by laying down indeed harmonized rules. Article 114 of the Treaty on the Functioning of the European Union. Now, there is a popular saying that if you have a hammer in your hand, everything looks like a nail. And it serves different, albeit complementary objectives and has a different mechanic.
Ms. Barrett, if I just may I just interrupt you shortly, because we do have a problem with the sound. We could just hear one sentence, then it stops, and then it just goes on with another sentence that has no connection with the one before. I don't know, may I suggest that you just switch off your camera? Maybe that does improve the connection, just to give it a try.
I hope this works better.
It sounds good at least, so let's see,
okay.
Let's see what happens.
And apologize again for that. So to highlight again that the DMA is there to create an EU-wide regulatory framework. It contributes to the internal market, and that's why it's based on Article 114. Now, I was saying that you have a popular expression that if you have a hammer in your hand, everything looks like a nail. And that similarly, as competition lawyers, we may be inclined to look at the DMA just through the lens of competition law. But the DMA is not competition law. It serves different, albeit complementary, objectives, and it also has a different mechanic. Competition law, of course, amongst other sources, has inspired quite a few of the obligations and prohibitions in the DMA. That's the first point of interaction. This is nothing new in the tradition of EU internal market legislation. Competition law inspired, for example, also the unbundling provisions in the third internal energy markets package, or the regulation of inter-exchange fees in the banking sector, or access regulation in telecoms. But the objectives of the DMA are different from the objectives of competition law. The DMA addresses issues of contestability and fairness well beyond what EU competition enforcement, with its focus on avoiding distortions of competition, could achieve. Fostering multi-homing, for example, or granting consumers and business users more control over their data. In that sense, the DMA interacts not only with competition law, but also with other sets of legislations like data protection legislation, consumer protection, or unfair trading practices. A second important feature of the DMA is that the legislator prescribes in a specific ex ante manner what a gatekeeper shall do and not do. And for us as Commission, it has been important to formulate Articles 5 and 6 in a precise and proportionate manner, zooming in on the known problematic behavior by very large platforms holding a gatekeeper position. In doing so, we wanted to give legal certainty to market operators, both potential gatekeepers and business users, and have a maximum preventative effect. And having learned our lessons from 20 years of competition law enforcement, we paid particular attention also to the economy of enforcement. It's crucial that the obligations and prohibitions contained in the DMA are applicable automatically and in full as a result of the designation as gatekeeper. It is for the gatekeeper to report on how it ensures effective compliance, and where needed, the Commission can specify the precise compliance modalities of certain obligations after a regulatory dialogue with the gatekeeper and involving also third parties. But it's within the discretion of the Commission to do so, and the regulatory dialogue in any event does not suspend the obligation. So beyond its differences in scope and objectives, it's through these different mechanics that the DMA complements and adds value to competition law. Now, once the DMA is adopted, as enforcers, we'll have several tools in our toolbox: the DMA, EU competition law, national competition law, alongside data protection tools, consumer protection, and so on. And each tool will have different features. This, I believe, will make us stronger, more efficient, and more effective. But it's clear also that to be efficient, as our resources will always be limited, and to be effective, we will need to cooperate and coordinate closely on what tools to use in any given situation. Now, we have a good tradition, I think, and basis to build on for such coordination in the context of the European competition networks, but we will also have to build on expertise of other bodies. Now, to summarize, in a nutshell, the DMA is internal market legislation in which specific obligations are set by the legislator, and those are applicable automatically to a company designated as gatekeeper and for the particular core platform service for which it has been designated. And in terms of governance, the DMA will be enforced centrally by the European Commission with similar investigative powers and right of defense provisions as in competition law. But in enforcing the DMA, the Commission will cooperate and coordinate with the enforcement of EU and national competition law, building on good cooperation with national competition authorities that exists in the European competition network. So I hope this was clear and you could hear the final part of the presentation. Apologize again for the technical disruptions, and looking forward to the rest of the debate, hopefully in better technical circumstances. Thank you.
Well, that's always the problem, even after almost 2 years of COVID, we're still having technical problems, but that's a different issue. We could hear you very well at the end, so that was very helpful. Though I still didn't quite understand whether the DMA is indeed the hammer or not, but that we can discuss maybe later. Thanks a lot, Ms. Bernhardt. We'll now turn to Andreas Mund, President of the Bundeskartellamt, or the German Federal Competition Office, I should probably say here. Mr. Mund, Ms. Bernhardt mentioned the Article 19a of the German competition law, and she also said a few things about the relationship of the DMA and she made quite clear that the DMA is indeed not competition law. Hence, I would be interested to hear from your side, first of all, whether you share the analysis of the Commission when it comes to dealing with the big tech platforms, and also how you see this interplay between those different regimes we're having here. On the one side, the DMA, which is not competition law, and on the other side, the traditional competition law as you're enforcing it.
Yes, Mr. Kafsag, many thanks for having me today. It's a great honor and it's a pleasure to discuss these complex matters here in this forum. I mean, you mentioned the COVID crisis already and what the digitalization has brought to us during that time. That is multifaceted, I would say. On the one side, we see how much the digital economy has facilitated our lives. On the other side, we have seen that big tech has become even much bigger, big tech. We hear even louder and more complaints about market foreclosure, rule setting by gatekeepers, data exploitation by ecosystems. And to protect markets, to keep them contestable and to take care of a certain fairness of competition has become even more important over time. In fact, I mean, the interesting question is, what is the relationship between the DMA and competition law? How should we organize the interplay between the European Commission and the national competition authorities in enforcing the DMA? And what about enforcing the national, maybe special competition provisions under the regime of the DMA? So what is important to know is we do not start from scratch. We have had very successful cases also at the national level. If you look at the Amazon cases by the Bundeskartellamt, I mean, it's a result of our proceeding that the sellers on the Amazon marketplace can sue Amazon with civil litigation today before German courts. Before our case, they had to go to Luxembourg, before a Luxembourg court with their cases. Well, good luck to a small seller that is litigating against Amazon. Another issue was that Amazon now is liable towards the seller on the Amazon marketplace. Look at the booking case that we have done. I mean, we have reinstalled the right and the freedom of hotel owners to fix their own prices for their hotel and not leave that to booking.com anymore. So what I want to say is there have been very successful cases by national competition agencies. I should mention in this respect, because this becomes more important later on, the Facebook case of the Bundeskartellamt. That is a case that stands for two things. The first one is we need more speed in our proceedings, be it at the administrative level, be it at the judicial level. And the other one is, this is a very fundamental case, because the Facebook case where we held Facebook liable to keep the data they gather and they process separate, that is a case that will be of utmost importance for digital markets, because data gathering and data processing is at the heart of those companies that have data-driven business models, and this is at the heart of the dominance of these companies. So I tell you that because it is important to see how much is going on at the national level. So now let's turn to the DMA. It is always said it is not competition law, it is regulation, it is kind of ex-ante regulation. Well, from my perspective, ex-ante regulation would be if we would tell companies beforehand if they were allowed to adjust their algorithm in a certain direction, or if not to do that. I think that would be regulation. But if you take a close look at the DMA, you will quickly see that it is deeply rooted and that it reflects to a very large extent, well, competition cases that have been done in Brussels, in Bonn, in Paris, in Madrid, in The Hague. So in fact, it generalizes in a certain way past and ongoing competition law cases. And I think that is a strong indicator that it is not so far away from competition law as many hold in the public debate. From this perspective, I also hold it as extremely important that the DMA in the very end will be enforced by DG Comp and not by another Directorate General, because the expertise of what is meant by the DMA is exactly in this Director General and not with others. Another issue, well, is the DMA really self-enforcing? That is also said, because it is said that it is regulation. I doubt to a great extent that it is really self-enforcing. And I wonder what happens if one of these companies that are subject to the DMA shows up at the commission and says, look, I've done this and that, but I'm completely DMA compliant. So believe it or not, but as a competition agency or as an agency that is enforcing the DMA, what do? Maybe at first sight it is DMA compliant. Maybe at second sight it is not. What does that mean? You have to lead an investigation. You have to open a proceeding because you have to find out, is a certain conduct of one of these companies, is it really in line with the DMA? I give you a very, very simple example, self-preference. We all agree that self-preference is something that should be prohibited to certain companies, maybe to big tech. But where does self-preference begin? Where does self-preference end? Is a certain conduct self-preference, yes or no? Well, that also in the future will be decided on a case-by-case decision. It may be an easy decision in some cases, but it may be difficult in others because the conduct that it is at hand for these companies can be very, very subtle to circumvent static do's and don'ts that you find in the DMA. So we are very much afraid, or I am very much afraid, that the DMA in the very end maybe is not as self-regulating, as self-enforcing as many believe today. So if this is so, we will see proceedings under the DMA. We will see investigations under the DMA, and who shall do that? Of course, you can leave that to DG Comp, as it is mainly foreseen by the drafts that I know. But I think it would be an excellent idea to include also National Competition Agency into the enforcement of the DMA. And I think that would have many advantages from many perspectives. The first one is, I have already mentioned all the cases that have been done at the national level, which means we have the expertise, we have the skills, we have the knowledge to do these kind of cases. Secondly, I think it will be very, very important that we don't see an enforcement bottleneck in the future. And I'm a little bit afraid that if it turns out, let's put it this way, that the DMA is not as self-enforcing as some say, then we will need all the power, then we will need all the enforcement capacity that we have. And what would make more sense than go back to the national competition agencies and include them in the enforcement of the DMA, also because the Commission might have different priorities sometimes. A certain conduct might have an impact also in one or two of the member states. So that might not be a priority of the Commission, but it can, of course, be a priority for the competition agency that you have in this respective jurisdiction. Another point is, Inge Bernhards said that already, we will have further cases also under competition law. The DMA will catch maybe only the tip of the iceberg, maybe certain conduct. There will be other cases at the level of DG Comp, at the European level. There were other competition cases under Article 101, Article 102, or under national competition law at the national level. So what I want to say is, be it as it is, we anyway need a mechanism for cooperation in Europe among, well, the European level and the national level in order to make sure that we don't tackle the same cases. We need to avoid a duplication of work. And of course, we need to make sure that we do not come to contradicting outcomes in certain cases. We have great expertise on doing that in the European Competition Network, the ECN, in which we do that since 2013, almost 20 years of coordination and cooperation. So we do not have to reinvent the wheel. Let's make use of the mechanisms that we have at hand. From my perspective, there has been an excellent proposal by the Friends of the DMA, France, Germany, and the Netherlands, where they have made the proposal to have a referral system within the European competition network with respect to the DMA, which would mean that, of course, it is up to the European Commission to designate certain companies to fall under the DMA and to be subject of scrutiny of the DMA, but that the EU could refer certain cases to national competition authorities in order to make sure that a certain conduct would be looked at and would be scrutinized at the national level. I think that was a great proposal, and I think we need further to discuss that. What is of utmost importance, last but not least, we have some specific provisions on the big tech companies at the national level. Here I refer to Article 19a that has been just introduced into German competition law at the beginning of this year. The Bundeskartellamt has opened proceedings against Google, against Apple, Facebook, and Amazon, proceedings in order to designate these companies to be an addressee of Article 19a of the German Competition Act. But we have also already initiated proceedings against these companies with regard to a certain conduct on the basis of Article 19a. Also here, we are in close contact with the European Commission, in close contact with our sister authorities in Europe. And I think what is of utmost importance that we keep this responsibility and this competence to pursue also further on these cases that we have initiated on the basis of Article 19a, German Competition Act, and that we can open new cases with regard to a certain conduct of certain companies. All this follows the red line that I do believe that these companies, or some of these companies, have become extremely powerful. And if we really want to set a counterweight against these companies, I think we need to join and bundle the forces of the competition agencies we have in Europe. We have a great chance to do that now in the framework of the DMA. Plus, we have lots of mechanisms at hand already in order to make sure that we are able to cooperate and coordinate properly and adequately, that we have no duplication of work, that we have no contradicting outcomes. So I think that is what we really must think of in terms of substance. I do believe the DMA will still be subject to a heavy debate in Parliament, in the Council, also maybe at the Commission level. I think here we will come to a good outcome. But these institutional issues, how to enforce the DMA, how to enforce competition law and the DMA vis-a-vis these huge and powerful companies, I think that is the center of the debate, and that is at the heart, and we must make use of all the capacity that we have. Thank you very much.
And good to see you again, Mr. Moon. Thanks a lot for your intervention. I don't want to spoil the fun, of course, but from what we are seeing with regard to the debate in the Council, the German, French, Dutch proposal you were mentioning has not gained too much support, to put it mildly, but we'll see about that maybe, or talk about that maybe a little bit later. But just to be totally, absolutely clear, the main point you're making is that we should still see a strong role for the national competition authorities, namely the Bundeskartellamt, once the DMA is put in place. Is that correctly understood?
Absolutely. I mean, it is not only about the Bundeskartellamt. We have seen other successful cases also in Paris at the Autorité de la Concurrence and in other competition agencies. And again, my first very important point is the DMA is not as self-enforcing as you might think today. We will see proceedings, we will see investigations. And if this is the case, I think the European Commission can use any support by national competition authorities in order to enforce the DMA properly, or to be supported by the national competition agencies to enforce national competition law.
That would include indeed that the national authorities could enforce the DMA themselves, and the Commission wouldn't be the sole enforcer of the DMA.
I think that would be the optimal solution. Here in Germany, just to put that very precise, we are in the favorable position that we have Article 19A already in our national competition law, which is very close to the DMA and which is very similar, and under which we have opened up so many proceedings. And well, we would want to get along with that. And I think this is also necessary, given the danger we see for competition in the digital economy, the most important sector for the time being.
Okay, thank you, Mr. Mund. Let's now turn to the other side of the Atlantic, and I give the word to Mark Neefer from the US Department of Justice, International Council Antitrust Division. What else could it be? Mr. Neefer, Frances Hogan said the EU proposals, and of course she was referring to the DSA, but I think that applies as well to the DMA as inspiration for other countries as the United States. And then again, the US has put forward some proposals by itself, which some people regard as far better than the EU proposals actually. So what I would like to hear from your side is, when you compare both approaches, would you really see the EU as the inspiration for the US? So would you say we've learned what we had to learn and we're now going for a better way? Mr. Neefer, you have the word.
Yes. So first of all, good afternoon, everybody. I'd like to thank the organizers for putting together this event and inviting me to participate. It's an honor for me to appear alongside such distinguished panelists to discuss such important topics. Before I get started, I need to state that my comments today are my own. They do not necessarily represent the views of the Antitrust Division or anybody else. With respect to your question, Hendrik, of course, these issues have been discussed widely around the world for the last several years. And there has been, I think, a robust international discussion. It's not clear to me that any one jurisdiction, any one agency has contributed more or less, or has put forward better or worse proposals. This is all part of a big international discussion. And I think there's been some robust cross-pollination across jurisdictions and across agencies that have led to the proposals that have been made, not only in the form of the DMA, but also in the US and in other jurisdictions around the world. So what I thought it might be useful for me to do today, if it's okay with you, is to give a brief overview of proposed laws in the US related to digital markets. I thought it would be useful to note some of the similarities and differences between the DMA and US proposals. Although it's not clear that proposed US legislation actually will become law, I think that a comparison might give us some insight into the direction that the US and EU are headed. So, as many of you may know, the Judiciary Committee of the US House of Representatives issued a report a little over a year ago that raised concerns about competition in digital markets. Several proposed bills have been introduced into Congress over the last year to deal with the concerns raised by the report. Now, to become law, these bills must be reported out of committee. They must be voted out of the US House and the US Senate. They must be reconciled if there are differences between the House and Senate versions. and then signed into law by the president. This is a process that can take months, and it's uncertain when or even whether any of the bills in the US will become law. But I still think it's instructive to compare proposed US legislation with the DMA to get some sense of the directions in which the US and EU are headed with respect to large digital platforms. So there are 5 key US bills that I'll mention briefly. 4 of the 5 bills apply to what are called covered platforms under US legislation. These are defined as large platforms that provide search, social network, or marketplace services and are critical trading partners. A critical trading partner is defined as a platform that can restrict or impede the access of a business user to a tool or service it needs to effectively serve its users. Now, each of the 5 bills deals with a specific policy area, and I'll turn to each in turn. First, the American Choice and Innovation Act Online is a non-discrimination bill. It prohibits discrimination by a platform in its favor, against a competitor, or between similarly situated third parties. The second bill, the Augmenting Compatibility and Competition by Enabling Service Switching Act, a very long name, which is sometimes referred to as the Access Act, appropriately mandates data portability and interoperability by a platform. The third bill, the Platform Competition and Opportunity Act, concerns mergers. It prohibits acquisitions unless the platform can provide clear and convincing evidence of no anti-competitive effects. Fourth, the Ending Platform Monopolies Act forces divestitures of businesses that create an incentive for a platform to favor its own products. And finally, the recently proposed Open App Markets Act prohibits large app stores from discriminating against or imposing unfair terms on app developers. So those are the 5 key bills that are under consideration. And there are, of course, many similarities between the proposed US legislation and the DMA. The notion of a critical trading partner under proposed US legislation is similar to that of a gatekeeper under the DMA. These are platforms that business users and end users in some sense must use. They are unavoidable for large numbers of businesses and end users. A second similarity, of course, concerns covered platforms. In practice, US legislation is expected to sweep in only the 4 or 5 largest tech companies, whereas the DMA is expected to sweep in a much larger number. However, there will be overlap in the platform subject to US legislation and the DMA. The 4 or 5 covered platforms under US legislation probably will be gatekeepers under the DMA. With respect to the US App Store legislation, it's unclear how many app stores will be covered, but at a minimum, the bill appears likely to cover app stores operated by the largest tech companies, including Apple, Google, and possibly Microsoft. So, in addition to those similarities, many of the mandates of the DMA are similar to those of proposed US legislation. Both seek to ban large platforms from using non-public information from business users to compete with those business users. Both mandate data portability and interoperability. Both ban the use of most favored nation clauses to some extent. Both prohibit platforms from tying their services to some extent. Both seem to allow sideloading of apps, as well as allow users to freely install or uninstall apps, and both prohibit discrimination in rankings and in other ways. So, in addition to those similarities, there are, of course, some obvious differences, and I'll turn now to those. First, there are differences regarding the definition of covered platforms. The DMA has a list of clearly specified core platform services for which gatekeeper status may be conferred. The US legislation for covered platforms, on the other hand, is a bit vaguer. Instead of clearly identifying specific services, US legislation refers to websites, apps, operating systems, digital assistants, or online services that enable a user to generate content or interact with content on the platform, that facilitate sales of goods or services, or that enable user searches or queries. Now, I suspect everybody has a sense of what some of these covered platforms might be the services they might be providing that are covered by the US legislation, but it's not entirely clear. And it seems to me entirely possible that US legislation may sweep in a greater number of online services than the DMA does in its definition of core platform services. A second difference, notable difference, is the opportunity for a dialogue. The DMA permits some dialogue between gatekeepers and the Commission, at least with respect to Article 6 obligations. US legislation, on the other hand, includes no explicit recognition of the possibility of dialogue. There may, however, be some possibility for dialogue in the US as the agencies go about trying to implement the legislation. A third difference concerns foreseeable gatekeepers. The DMA reaches foreseeable gatekeepers, which are companies that are not actual gatekeepers, but may be in the near future. US legislation does not refer to foreseeable gatekeepers. It refers only to covered platforms which currently are large critical trading partners. Another difference concerns transparency for advertisers into ad tech. The DMA requires that gatekeepers provide advertisers with access to information and performance tools, which will give them greater insight into ad inventories and the prices they pay. US legislation, on the other hand, includes no provisions expressly related to advertising or ad tech. There also are differences concerning the combination of personal data. The DMA prevents gatekeepers from combining personal data from core platform services with personal data from other services or third-party services, unless users consent. US legislation includes no such express provisions. However, it does limit the use to which data may be put in certain circumstances. Finally, one big difference I'll note between the DMA and proposed US legislation is that the DMA contains no substantive merger provisions. The only merger provision, as far as I understand the DMA, concerns reporting mergers for purposes of determining whether a gatekeeper has added core platform services under the DMA as a result of the merger. As I mentioned, the Platform Competition and Opportunity Act in the US makes it more difficult for a covered platform to successfully acquire a competitor or a potential competitor. So I'll conclude by stating the obvious, which is that large digital platforms have caught the attention of lawmakers not only in Europe, but in the United States. It currently appears as though the EU is much further down the road towards legislation addressing these concerns than the US is. But by and large, the DMA and proposed US legislation seek to reach very similar behaviors by large platforms, with a couple of notable exceptions. The key one, as I mentioned, has to do with mergers. So with that, I'll end, and I look forward to the Q&A. Thank you very much.
And if I may start with one or two questions already, because I mean, if I understand it correctly, the major difference is that the EU side doesn't foresee anything about killer acquisitions, as we like to say. You said merger provisions. Is that, from your point of view, a gap that should be addressed in the EU legislation?
I will not speak about what the EU should do with respect to legislation. I will say, of course, that concerns about killer acquisitions are widespread around the world. They are, as I said, a subject of concern that has apparently inspired legislation in the US Congress. You know, these are very difficult questions to think through. And I don't have any strong opinion, and I certainly wouldn't pretend to weigh in on what Europe should do with respect to killer acquisitions.
Fair enough. And the other one is, of course, and then that's probably even harder to answer the question. I mean, you said it's not clear if those bills you were talking about ever will become US law. If you had to put a figure on that, how likely do you think it is that we'll see those bills becoming reality?
I would not even want to venture a guess. One, I'm not a keen or close observer of the political process in the United States. And I think even those that are sort of steeped in the process have a hard time predicting what may or may not happen with respect to these bills. So I have no strong opinions about the likelihood of any of the proposed legislation becoming law.
Okay, thank you. But I had to try, of course.
Of course.
So let's now turn to the companies that might be affected or will be affected, in fact, if the DMA at least becomes reality. And that's, should I say Meta now, Facebook, Microsoft, and Shopify. And we'll now turn to Ines Bodenstein, legal counsel at Gleis Lutz in Stuttgart, Germany, who's representing, and I'll stick to Facebook, and give us a lawyer's perspective when it comes to the proposals on the table. And I would, of course, be interested to hear from your side what you think about Article 5 and 6, specifically the so-called black and gray lists that are part of the DMA, and whether you think that approach is, practically speaking, doable when I take into account what Mr. Mund said just before. Thank you.
Thank you very much for having me on this panel. As counsel from Gleis Lutz, I will indeed now turn to the lawyer's perspective from private practice on the draft DMA. And in this respect, I'd like also to refer to the position paper of the German Bar Association on the DMA that takes a position on the DMA. And I'd like to highlight three aspects from this position paper, starting with the general character of the DMA and its relation to competition law. And we have already heard from Mr. Mund and from the European Commission that it's quite a heated debate whether it's a specific piece of regulation that we have here in front of us or whether it is competition law. And I'd like to bring the point forward that it's indeed a competition law. If we look at the objectives of the DMA, this is the contestability of markets, to foster innovation, to drive consumer welfare, as it stands in one of the last amendments from the European Parliament. And if we compare this to competition law, it's indeed fairly similar what competition law is trying to achieve: the openness of markets, the open competition, and consumer welfare. So the objectives are quite similar. And it's, as Mr. Mund mentioned, not by chance that those cases that have stood precedent for many of the Article 5 or 6 provisions are from competition law. And so I would indeed say that we have now here a new piece of competition law. We may call it the fourth pillar of competition law, the previous three pillars being horizontal, verticals, abuse of dominant position, and merger control. And now we have a fourth pillar complementing the framework of competition law and including in its house individual pieces of legislation or case law that we have seen in competition law, like the essential facilities doctrine, like self-preferencing, or like an extensive interpretation of tying and bundling in cases of free extra services. And these individual cases that we have seen so far now go into this broader framework of the DMA and have now become necessary because the aspects are more prevalent with the specifics of the digital economy. And so what consequence is there if the DMA is competition law? We are not on a green field here. We have established principles in competition law, and we should make use of these principles of competition law for the DMA as well. This could relate to procedural aspects. We have a whole set of procedural norms, how to enforce competition law, how to have a coordination between national competition authorities and the European Commission. We could have made use of that. But it does not stop with procedural aspects. There are also material aspects that could have been proven good for the DMA, including the weighing of interests of the pro and anti-competitive aspects that we have seen in numerous cases in antitrust law, and that should also be transferred to the DMA. But irrespective of the character of the DMA, if we have here a specific piece of regulation, or if it is competition law, we need to have a clear coordination between the enforcement of the DMA and competition law. Competition law is applicable besides the DMA, but we need to have a close coordination. As things stand now, we have a risk of double jeopardy. so that specific forms of conduct can be caught by the DMA as well as Article 102, so the norm on abuse of dominance under European or German law. And so it could lead to the situation that a certain conduct may lead to a fine under the DMA as well as competition law. And this would not be admissible. This would be against the principle of ne bis in idem. So we need to have a close coordination here. What is in the DMA and what is in abuse of dominance norms. We also need a coordination between the DMA and Section 19A1, A1 or 2 of the German Act Against Restraints of Competition. So the new clause on gatekeeper behavior that we have in the German competition law, and that, as Mr. Mund has said, follows quite the same objectives as we have for the DMA. It's very parallel what has been done with the 19A and what is about to be done with the DMA. So how should the DMA and Section 19A stand to each other? And we have a certain provision in the draft DMA which says that 19A can only be applied insofar as the DMA does not cover the behavior or does not cover the entity. So if it's not a gatekeeper under DMA. So for all our pending and future 19A proceedings, we will need to have an assessment whether the conduct would fall under the DMA as well, or whether the entity is a gatekeeper under the DMA as well. And if it would be this case, this would block the 19A enforcement. So this will shape our future enforcement of 19A in Germany. Now let me move to the second point, and actually the question that you raised to me. So what about the Article 5 and Article 6 provisions that we have in the DMA? Some of these provisions are quite neatly framed, but this is because we know these cases from previous competition law cases, from self-preferencing or the wide parity clauses. So some of these provisions are clearer than others in Article 5 and 6. But we have other provisions which are worded in a rather broad and vague way. We have unspecific legal terms. We have quite abstract descriptions, almost leaning towards a catch-all provisions. We have room for interpretation and room for discretion. And this will make it extremely difficult to reach this notion of self-enforcement that is should actually be provided for in the DMA. I can hardly think of an Article 6 provision which could be self-enforced without opening a dialogue with the Commission, or the Commission opening a proceedings to specify the measures that a gatekeeper shall implement to comply with Article 6 provisions. And so we have quite high costs and risk of enforcement as these clauses are framed in the way as they are. And these costs and risk of enforcement are detrimental for both sides, both for the gatekeepers who have to comply with these provisions in the future, but also for all the other digital players out there who want to challenge certain kinds of behavior that might endanger their business model, or which would not open them up contestable market positions. So in order to lower costs and risk of enforcement for both sides, it would be good, it would be favorable if it could be achieved that the provisions in Article 5 and 6 are worded in a clearer and more focused way. But I know I cannot turn back the wheel. We seem to have a broad political consensus that Article 5 and Article 6 are worded in the way as they are, to have a comprehensive approach, one might say overly comprehensive approach. But if we go down that route, then we need an efficiency defense in Article 5 and Article 6 as well. Why do we need it? From an economic perspective, to not include behavior that is not detrimental to the openness of market or the contestability of markets. So in several of these clauses, we have pro as well as anti-competitive effects, depending on the ecosystem, depending on the specific service, if there are innovations involved, or what effect we have on transaction costs. And this should need to be included in our thinking about these provisions, and it could be done under the headline of an efficiency defense. We also need an efficiency defense for reasons of fundamental law. We are challenging here fundamental law provisions of gatekeepers, and so we need to ensure that what we are doing here is proportionate. And in order to ensure this proportionality, an efficiency defense will do it, like we have seen in competition law cases for several years now. The efficiency defense has proven quite valuable in many competition law cases in all the other pillars of competition law that I have raised. And indeed, for some of the provisions in Article 5 and Article 6 that might not be as debatable as others, such efficiency defense and weighing of individual interests has already been done during extensive antitrust proceedings. And so this is why I would like to argue for the need of an efficiency defense in the Article 5 and Article 6 provisions as well. And I understand that we should not jeopardize the expedient enforcement of the DMA, which is at the core of this legislation. So I'd like to refer to a suggestion of the German Monopoly Commission in this respect. They also argue for the inclusion of an efficiency defense, and we could take a procedural approach to ensure that compliance is not slowed down extensively. And they are arguing for a kind of downstream proceedings or subsequent proceedings. So the gatekeepers have to comply with Article 5 and Article 6 within this 6 months time frame, depending on change, but they can apply at the same time for an exception under the efficiency defense. And the Commission would have 6 months, so we have here parallel in timing, 6 months to decide on such efficiency defense. And if they do not come to a decision within these six months, there is no exception for efficiency. And in concrete, on what kinds of efficiency am I talking here? I'm talking about economic progress, about technical developments and innovations. And there are certain cases that you can bring forward for several of the provisions. One among them being, as already been raised, this provision on not using business data for competitive purposes. This business data can have various forms. This provision was worded with a view to the Amazon proceedings. Don't use the pricing information from retailers on your platform to undercut these prices with your own offerings. But the provision as it is worded by now is not only narrowed down to these pricing information, but to all kinds of information. And this could lead to an over-enforcement. So let me now move to the last aspect that I wanted to raise. This is procedural aspects. As I've said, if and as the DMA is competition law, we could have made use of the procedural norms that we have in competition law and that are well established, tried and tested. But well, we have the proposal of a new enforcement system, rather complex mechanism, I have to say, with various deadlines, notification obligations, and it has been built from scratch. And for these procedural mechanisms, it's important that we keep in mind the defense rights of the undertakings concerned, including legal privilege for lawyer conversation, the right to be heard, and also effective judicial review. So we have to keep in mind these notions when looking at the enforcement mechanism in the DMA. And the last point that I would like to make is that this is about the fine proceedings. We have two ways of enforcement in the DMA. We can have non-compliance decisions or even a fine decision. And I'd like to argue that these fine proceedings should play a clear subordinate role compared to non-compliance decisions when it comes to the enforcement of the DMA. These fines can be substantial. The last suggestion of the European Parliament, I think, amounts to 20% of the group worldwide turnover. But these fine proceedings should play a subordinate role for two reasons. First, it's again a fundamental law principle. We need to have legal certainty, foreseeability, and proportionality. So if some of the clauses under Article 5 and 6 are worded in such a broad way, it would be against the principle of legal certainty to come down with fines for non-compliance if the behavior in the first place was not clear enough. But second, Also here looking to the other side, to all those digital players out there that want to have contestable markets, we can see from comparing the approach of the German Bundeskartellamt and the European Commission that non-compliance decisions or proceedings to stop behavior have proven to be more effective than to go for the big shot of fines. So rather go into the market, stop the behavior if it's really illegal, and do it in a timely manner, then reach out for high or maybe even excessive fines. So to summarize, the 3 points that I wanted to make during my statement is, first, the DMA is indeed competition law. Second, as such competition law, we need an efficiency defense for Article 5 and Article 6 provisions. And third, fine proceedings should play a subordinate role in the hierarchy of the enforcement. Thank you.
Thanks a lot, Ms. Bodenstein, for that broad overview of the problems you're actually seeing with the proposal that's on the table. And let's now turn directly to Kara Muscat, because we're running a little bit out of time, which is of course entirely my fault because I had to ask questions before, which was not foreseen. Kara Muscat is senior attorney at Microsoft Brussels in Belgium. And just to cut it short, what I'd be interested to hear from your side is mainly what you think about the points Ms. Bodenstein made at the end, Article 5 and 6, of course, the idea of an efficiency defense within the DMA, and the remedies, the enforcement of the remedies. Mr. Muscat, you have the word.
Yeah, thank you very much. It's a pleasure to be here. Just to avoid any speculation, this swollen eye is not from my last discussions about the DMA. It's just an eye infection. Apologies, I will turn a little bit to the right because I'm a little bit conscious about how awful it looks. But be that as it may, I'm supporting Microsoft's compliance efforts in the EMEA region. And I'm very excited to be with you here to actually contribute to the discussion. Because this is really a paradigm shift, what we are discussing in terms of European competition enforcement. Let me emphasize at the upfront that at Microsoft we have been supportive of the Commission's proposals, or as Andreas Mund has put it, like Germany, France, and the Netherlands, we are friends of the DMA. We agree with the need for clear and effective rules for gatekeepers. The Commission proposal rightly addresses the unique power certain platforms have, and that power is a result of these platforms providing access to customers for businesses. And the specific dynamics of these markets and the specific role gatekeepers play in these markets justify this form of market intervention through regulation, as opposed to a kind of case-by-case analysis. And I might there already slightly deviate from the position Ines Bodenstein took before, and might be more reflective of other gatekeepers which are more on the receiving end of that regulation. We are both at Microsoft. We will be in scope of the DMA with some of our services, so we'll be a gatekeeper, we'll meet some of the thresholds that apply or to be presumed a gatekeeper in the first place. And we are active across the different core platform services. So there is a high likelihood that we are in scope, but we are also beneficiaries of this regulation. We have advocated for years for rules and intervention in digital markets because we try to compete in search, and we are subject to certain or dependent actually in trying to bring our services to customers, in particular on mobile phones, and therefore very much appreciate the ideas to actually have rules how app stores should operate. I would like, I'm coming to your questions. Hang on with me. But I would like actually to focus on 2 points which are kind of related to the questions you have raised. And One is the focus on the DMA, and you heard others before. A focus might be important for the effectiveness of the DMA, and the DMA should be about gatekeepers. And then secondly, let me touch on this question of regulatory dialogue, because it's also quite close to my heart for the same reasons. As a competition lawyer, even though there might be clear cases, even though we would agree that there are a number of problematic cases, there is not always an easy solution to these cases. And a lot of practices, in particular in digital markets, are not as clearly wrong or right. We have seen that in our involvement in a lot of these cases, and I will get to that in a minute. But let's speak about the focus that of the DMA that should be on gatekeeper. It is a question of the effectiveness and the limited resources that the DMA should deal with the real problems we are seeing with digital markets. Currently, and in particular in the political debate, we see much more ambitious proposals that are trying to subject any problem in digital markets and want to introduce regulation for digital market generally and impose one-fits-all solutions and black and white prohibitions and obligations. And there is the risk that this will rather harm competition than promote the competitiveness of European digital markets. Let's remember that market regulation is a prescription drug that is dangerous if it is distributed over the counter. That's how Bill Kovacic, a professor at George Mason University and former member of the Federal Trade Commission, has put it, and that resonates very well with me. The regulation has taken its justification from the specific dynamics that apply to gatekeepers. The broader it gets, the higher the risk of those unintended consequences of going too far, of prohibiting and hamstringing market participants in digital markets to compete and do what ultimately customers want, or what might improve products, bring innovation to the market, or simply bring more competition. Let's not forget, some of the gatekeepers might be the strongest competitors of other gatekeepers in digital markets. So as we are interfering with that competition, that can't be random. It needs to be limited to what is necessary, not just to make the DMA proportionate, but to ensure that these markets remain competitive and produce the right results, give opportunities for European businesses to grow, and ensure that users ultimately benefit and businesses benefit from digital innovation. In the political debate, I often hear the argument, why should we care about gatekeepers? If the DMA hits the right people, who cares what's in it? But let's not forget that there is competition we are interfering with. And at least as competition lawyers, but I think most of our economists in the Western world believe that competition is the right way to produce results, and that regulation is only a second best option, which should be applied only in exceptional circumstances. We are therefore very worried about suggestions to extend the scope of the DMA to software licensing. Software services do not intermediate and don't raise gatekeeper concerns that the DMA wants to address. The complexity of different software licensing business models isn't a good match for a quick fix solution. What actually currently is proposed in terms of fair rules for software licensing has been proposed for quite some time by the by far leading cloud service provider, AWS, and will largely benefit AWS and Google. And if we don't look at this and just submit and accept some black and white rules for very complex business models in digital markets, we'd rather harm competition than bring more competitiveness to these markets. Let me quickly touch on the need for regulatory dialogue. We have arguably, and by we I mean Microsoft, and that's when I joined the company. We have been subject to the very first competition case concerning digital markets. And we have been involved in a number of these cases. And I have first-hand experience how difficult it is to find some real solutions to the problematic cases. There is not this silver bullet, let's be honest. And now you want to tell gatekeepers they should go find it, implement it, and then all the problems are solved. I'm very much with Andreas Mund that self-enforcement might be wishful thinking. We had competition rules for years, and they were self-enforcing. You were not supposed to abuse your dominant position. Nonetheless, you had dominant companies, including Microsoft, abusing their dominance. Some might have not known better, but some knew better. So do you really want to leave it to the gatekeepers to decide that case? I'm hearing quite a bit that only gatekeepers argue for regulatory dialogue. But let's put this on the records. It's not just the gatekeepers calling for that. It's businesses that want to hold gatekeepers accountable, that need that clarity. It's gatekeepers that want to comply with the law and make a difference and ensure that markets become more competitive and fair and are looking for solutions and need help. The only solution for that is not a political debate. The only solution is someone doing their homework and competition authorities getting to work and do their job in finding solutions together with all the stakeholders, the customers that are affected, the companies that are involved, and policymakers or other stakeholders in society calling for a solution for certain problems that we are seeing in digital market. That might take time, but let's take that time rather than leaving this to the gatekeepers. Wait until they violate the law, wait until the commission goes after them and imposes the fine, and then where are we? Where we are right now with competition rules that we start litigating for years. That is not the solution. And someone has to call out that the emperor's clothes are non-existent. We need to have a regulatory dialogue to ensure that these rules, which are very black and white, and for each of the 5 and 6 obligations and prohibitions, there are all these unintended consequences. We need to have clarity. We also need to have clarity where these rules don't apply. We know where they apply. We have decades of experience with digital enforcement that we know where the problematic cases are coming from and how they should be understood. But how do we then apply these rules to new business models and very different business models? It is not obvious. So let's engage in that dialogue. Let's make sure that it is not an endless dialogue, but that's just a question of procedure. We can easily design a procedure which is time efficient. We don't need to throw it out just because we can't design the right solution. So let's be more ambitious about how we do that. And that can be, by the European Commission and the national competition authorities putting their heads together on these cases. And a lot of resources are needed to deal with the problematic cases. And if the DMA is cast too broad, there will be a lot of resources needed to deal with the unproblematic cases because of confused users, because of confused businesses calling for justice and wanting the DMA to be applied. So again, 2 points I wanted to make. Let's be careful. Let's think about what the DMA was meant for to regulate large gatekeeping platforms and make sure that it stays focused on that and not fail on that and become ineffective. And secondly, let's continue this discussion about what the right solutions are. And that should take place beyond the discussion of this legislative proposal in the procedures around the designation of the gatekeepers and which rules should apply and how. Thank you very much.
Thank you, Mr. Maske. So let's now turn to somebody who is representing some company that is not a gatekeeper. Indeed, that's Shopify. And I'm glad that I made it to shop and didn't say Spotify, of course. That's the one. And let's turn to Matthew R. McGuire, who's representing Shopify. And what, of course, I would like to hear from your side is, after listening to what Mr. Maske said before, is what do you think about the scope of the DMA, particularly when you take into account what Mr. Niefer said before, that in the United States, there's a clear focus on 4 or 5 companies, whereas in the European Union, it's much wider. And then just picking up what Mr. Maske said, what do you think about these ideas about regulatory dialogue, etc.? Is that actually something you think is useful, necessary, or just something that will delay the whole process?
Absolutely. Thank you so much for having me and for posing those questions at the start. It's a real pleasure to be here with everyone. Our focus, and I'll have sort of 3 basic points to sort of walk through this afternoon, are around the scope of the proposal from Shopify's perspective. I think we're likely less known than some of the others who are speaking, certainly Microsoft, and concerns about whether or not the proposal is tailored sufficiently. We agree that the pro-competition goals are certainly laudable, and we're very supportive of it overall. But I'll just frame the company a little bit in the context of the way the Commission lays out the gatekeeper designation to give everyone a sense of why we think more clarity would help or why it could be more tailored. Essentially, the way Shopify's platform operates is it is, in effect, software. It is anyone can come sign up and use software to operate a business, even if they've never done it before. It's a no-code solution, and it's used by more than 1.7 million businesses around the world. But it fits more close, we think, the definition of an online intermediation service, because it is set up to allow on a contractual basis between us and a business to allow them to sell their products to end users. And then as you look through Article 3, it's hard to tell exactly if Shopify would be covered. But we don't really think that it's intended to be, and we often don't, everyone reacts with the idea that it's not meant to be. And part of the reason why this is important from our perspective is the goal of Shopify is to allow independent business owners who want to remain independent from some of the large online marketplaces to do so that they don't have to go subject themselves to the terms and conditions from those marketplaces. They can build their store with us, use channel integrations to reach those marketplaces, and remain independent in a way that we think helps competition and allows for innovation. The concern that we would have in general is how some of the requirements, especially in Articles 5 and 6, would apply to a platform like ours if we were subject to the gatekeeper rules. A ready example would be Article 5A, which sort of prohibits the combination of data that is obtained from different pieces of the business with the core platform service. And that would be problematic for the way the platform works, because we don't control the data that our merchants have. They're the data controllers for purposes of GDPR, and we process it at their exclusive direction. But we process it together so that they can understand where their customers are from a marketing analytics perspective, for example. And so we're worried that if we take away that ability to provide those types of services to merchants, it sort of forces them to go use the gatekeepers, because it's limited innovation in the market in a way that I don't think the DMA actually intends to. We are, to answer the question, we are very supportive of a concept of regulatory dialogue, and we're supportive of it in 2 respects. One would be on the front end with respect to the presumption of whether or not you're a gatekeeper. So to the extent that a company like ours could be caught in the gatekeeper definition, and it's not intended to be, having a very concrete and clear process to come to the Commission to get a decision or have a determination that no, in fact, you're not a gatekeeper, because you offer software, you don't intermediate between buyers and sellers, you don't have a captive set of customers in that sense, would be very welcome, and is something that we're very supportive of on the front end. We also would support regulatory dialogue generally if you are subject to Articles 5 and 6. We think there are just a lot of benefits that come from having good faith and serious conversations about how those requirements will apply to a great number of different business models. It's the beauty of horizontal regulation, as you cover a lot of people who do things differently. And I think as long as you set up a process that is efficient and that doesn't allow for, sort of endless delay, that is targeted at actually, reaching the right result for the right company, given the circumstances, that would be a very beneficial thing to have as part of the DMA proposal. The other piece that I wanted to flag this morning that is a little bit different is just the way is to step back a touch and look at the overall landscape in Europe and the way the pro-competition market contestability goals of the DMA are actually a little bit in tension with how some of the other regulatory proposals in Europe are coming together. So the Digital Services Act, just to put out there, is sort of going from a horizontal to more of a vertical regulation, especially in the commerce space around online marketplaces. And we've seen a great deal of tension between how the rules and regulations that would be imposed through that type of regulation would actually have the consequence of reducing innovation in the market. And I think is fundamentally inconsistent in some ways with the pro-competitive goals of the DMA, where if you overregulate the way the markets work and how businesses in the markets operate, you sort of consolidate power back with the companies that have the most to gain, the most ability to comply. And I think that is just a concern that we have in mind, wanted to sort of raise for everyone's discussion. But all told, from Shopify's perspective, we really don't believe that we are a gatekeeper. As Dr. Maska said, essentially software doesn't control users the same way as other services. That is at bottom what the core platform service from Shopify would be. And it's trying to figure out the right way to tailor the DMA so that companies like ours, which we think are helping competition and innovation in the marketplace and helping European businesses reach their buyers wherever they happen to be in the world, is a positive, and ensuring that we don't have unintended consequences by applying these rules more broadly than may be preferred.
Thank you, Mr. McGuire. That was short and crisp. Very good, because otherwise we would have lost much more time, and that would have made my life much more difficult than it already is. So let's now turn to the academic world, and that means to Professor Dr. Teresa Rodriguez de las Heras Valles, if that's at least close to being pronounced correctly. I tried my very best. It might not have been good enough, but she's professor at the University Carlo III in Madrid, Spain, and just very, very shortly, I'm sticking to what Mr. Maska said, but he said the unintended consequence of the DMA could be that we actually see in the end less competition and not more. And just coming from that idea, do you share this point of view? Do you see the risk, or would you say that's exaggerated and that's not actually the risk we are running? Thank you.
Thank you very much. The pronunciation of my name was perfect. So thank you very much for this effort, and thank you very much for the invitation. I appreciate very much the question that you raised, because it gave me the opportunity to focus on the two main issues that I would like to discuss and share my views with you. And they are both very much related to the which extent the DMA in demarcating the scope that, as I will explain in a minute, is based on two fundamental core element, the idea of core platform services and the concept of gatekeeper, to which extent this definition of the scope is indeed too broad, or on the contrary, too narrow. So what could be the unintended consequences in the market, and in particular in the level of competition of the market, if this scope of application is capturing too early certain companies that are trying to emerge and to enter into the platform economy? So I would like, with this idea in mind, I would like to share with you some consideration, because in fact, the delimitation of the scope in the DMA is fundamental for many reasons. The first one is because is indeed the reason, the justification why we need the DMA in combination with the competition law as it is at the moment. Second is fundamental because limit and set certain rules and conditions to avoid or prevent any discretionary action by the Commission. And this scope delimitation, this scoping exercise is based on two fundamental elements that has been discussed during all the panel. There is the core platform services and the criteria for the designation of a gatekeeper. I have several considerations about the current status of the DMA in relation to two main elements. The first one is the core platform services. The DMA has decided to use a list-based approach, according to which only those services listed in Article 2 qualify as core platform services. That certainly provides certainty and predictability, and I do perfectly understand from the perspective of the market how that could be a merit of the DMA. But on the other side, my concern is to which extent this list of different core platform services are indeed covering properly all the existing business model and all the future business model in a way that is proportionate and is equivalent. Or on the other hand, to which extent the mechanism to adapt the DMA, thanks to Article 17, to new business model in the future is speed, is flexible, is versatile enough in order to accommodate the DMA to the future business model. Indeed, my main concern is to which extent this list of core platform services are really representing a technology neutral approach, to which extent, for instance, distributed ledger technologies, just to give an example, are properly covered by this list of services. And on the other hand, and probably even more important, to which extent this list is business model agnostic or business model neutral. If that is not the case, that could create a regulatory asymmetry in the market. And that could be creating a situation that even if at the moment we think that is providing certainty because we have a list of specific services, because for me the distinction between the services is not very clear, that could create certain gap, certain overlaps, and certain business models that are not properly covered, even if that should be covered. What that would be my proposal? Instead of a closed list of a specific core platform services, a kind of functional definition of core platform services. I know that that means probably compromising the high level of predictability and certainty that we have at the moment. But a functional definition is, in my opinion, covering more properly all the different business model, all the different version of core platform services in the market. And therefore, if there are equivalent risks, we should have equivalent rules. If that means that we are opening too much the scope of application of the DMA, is that a problem? It is not a problem if we counterbalance this broad scope with a very sound, with a very strict and much founded and justified designation of gatekeeper. So in my opinion, the scope should be broad in defining core platform services, and what has to be extremely rigid and extremely strict and well justified is the criteria for the designation of gatekeeper. I have here another view to share with you. Even if I believe, according to recital 15 to 28 of the DMA, that this is indeed the underlying approach that the DMA is taking. However, in my opinion, it's not completely clear throughout the text. What is this approach that I am questioning? I think that there is a very different impact if the DMA adopt a service-based approach for the purpose of applying the different quantitative and qualitative criteria and therefore designate gatekeeper, therefore the provider of a core platform service. This is a service-based approach that, in my opinion, should be the one adopted by the DMA, compared to a provider-based approach, according to which the criteria for the purpose of designating the gatekeeper, they are applied or interpreted in relation to the provider as a unit, as an economic unit. Why I believe that a service-based approach is clearly preferred and advisable, precisely for the reason that the moderator asked at the beginning of my intervention, because a provider-based approach could have unintended and unwanted consequences, limiting competition, for raising barriers to entry. Why and to which extent? If the approach taken is based on provider, that could mean that non-platform business that decide to enter into the business, platform business economy, I would say, and started to provide core platform services, they could be designated immediately gatekeeper because of their the magnitude in the non-platform economy. And therefore, that could mean that we are capturing too early competitors to the existing incumbent in the platform economy. So my proposal would be to have a service, a very clear throughout all the provision, service-based approach. Let me just conclude with a final comment. What is the relationship, the interplay between the DMA and other legal acts that are proposed, are already adopted? To which extent the concept of gatekeeper should be aligned with the concept of very large online platform that we have in the Digital Services Act? To which extent we are going to have a feedback between the regulation platform to business and the DMA? For example, the communication that help the platforms according to the platform to business regulation to identify what is the level of transparency in a case of algorithmic decision making. To which extent this interplay is going to be a feedback, is going to be a complementary interrelationship between the two. To which extent in some of the obligation under Article 5 and 6 of the DMA that are related to data policies, the DMA is going to enhance the protection of the consumer compared, for example, to the GDPR. So let me just conclude with a summary of my views. I think that the core platform services that at the moment are listed in a closed list of a specific core platform services should be complemented or replaced by a functional definition of core platform services. Second, that should be certainly counterbalanced by a very specific and clear condition for designation of gatekeeper, and that should be based on service instead of based off provider. And third, it is interesting to see to which extent there is an interplay between the DMA and other legal acts in order to guarantee a perfect consistency and coherence in the entire system. Thank you very much. I'm happy to discuss further during the panel and the debate. Thank you.
Thank you very much. And that's indeed something I would at least suggest we should discuss further later on. Let me now turn directly to Professor Dr. Ruprecht Potzun von der Heinrich-Heine-Universität Düsseldorf in Germany. And just simply to make my life easier, Mr. Potzun, just ask the same question to you as well. I mean, DMA, something that helps to create competition or something that has the potential to end up with less competition than actually wished for? Thank you.
Thank you, Hendrik, and thanks DRV for the invitation to this great panel. I will answer your question, I promise, but let me start with a point that makes it very important, or that is very important and that we haven't really touched upon so much yet, and that is enforcement. I think that enforcement of this act matters so much that we should be very clear whether the enforcement that we currently see is something that we is a design that we find useful, because we can have the best obligations in the world, we can sort of have the best material substantive rules in the world. If enforcement is not sort of strong enough, tough enough, we will not reach any of the aims, be it competition, contestability, fairness, whatever you may call it. So if I look at enforcement in the current draft and in the DMA discussion, I think 3 points stand out. The first is, I wish to know, I hope that Inge can comment on this later on maybe, who at DG Competition will deal with that. Ines Bodenstein pointed at the issue that we do not yet see sort of some of the procedural issues solved, that there are maybe new procedural routines to be established, etc. And I wonder why don't we simply give all this to DG Competition? They are well trained in dealing with people like Karel Maske and Ines Bodenstein and others and such companies and the like. They have the procedural routines. Maybe we can even refer to Regulation 1/2003 so that we have all that in place, that otherwise we risk to have long battles about and problematic issues about. So that's the first question on enforcement. What's the internal institutional design that the Commission chooses? And I wish for DG Comp to be in the driving seat, to be ready on day one with the proceedings. The second point is, and I want to second Andreas Mund in this, I'm pretty sure the Commission cannot do this alone. It needs the support of the national agencies. Andreas Mund has already put forward many of the arguments. Let me just point at two things. The first is, the Commission is a political body. It takes the decisions in a political way. It sets priorities in a certain way. And now at present with Madame Vestager and Monsieur Breton, we have two commissioners who are very much in favor of regulating big tech. But what happens next? What if the next commissioner takes a different route? Then we may have rules in place that maybe where we have no staff to enforce, or where there's no priority to enforce. And there should be a fallback position with the national competition agencies that can take up these cases, that can help the Commission in monitoring and enforcing. I think that the role should be even a bit stronger than the Friends of an Effective DMA envisage. And I think of something like the ECN we have in competition matters. And the second reason for that is that those who should profit from the DMA. I mean, we are not doing this to punish the GAFA companies, but we are doing this to help business users and other users in their dealing with big tech. They need an easy mechanism where they can complain to, where they can go to solve their problems. Philip Marston and I, we wrote a paper even before the Commission came out with its draft saying enforcement matters. We need platform complaints panels, easy places, fora where you can go to, where you can complain regarding a certain behavior, say a violation of Article 5 and 6. And then there's someone who helps you quickly and adjudicates on the matter in a quick and timely manner. I don't see that in the current draft. I don't see that small business sellers turn to the European Commission in Brussels, take their case there and initiate a big proceeding or so according to the DMA. I would wish for something that is much easier to deal with, and there the national competition agencies could play a role as such platform complaints panels. And that leads me to the third point in enforcement, and that third point is private enforcement. I was sort of stunned when I read the position paper of the Deutsche Anwaltverein, since I thought that advocates would always sort of favor different routes to get the law enforced. And then I read in this paper that the DAV is not in favor of private enforcement of the DMA. I think that this is not a question that the DAV or the DMA or the Commission will judge on. It's probably a question for the Court of Justice to decide whether the rules are so self-executing enough that they are sort of can be relied on in private enforcement. But I think that private enforcement can play a very powerful role, again, complementing the European Commission, helping businesses that can go to courts and try to enforce the act. But obviously, in the current form, we need more, say, coordination mechanism. We need more rules on standing, on maybe some help that you can receive if you want to take your case to court. I think we have seen a couple of cases in German competition law where private parties sued gatekeepers and were sort of successful with that, or at least the proceedings were very good and interesting and pushed forward the whole regulatory debate. And therefore, I would very much favor that we open up the pathway for private enforcement in a better way, and that there are some coordinating rules in the proposal that help to pave this way. Now, this is sort of my take on enforcement. Enforcement matters. It needs someone at the Commission being strong with that. It needs the national enforcement agencies, the competition agencies to play a larger role. And I would also favor private enforcement with that, particularly so that we have a easier way for business users to monitor, to act, and to rely on these provisions. Now, speaking about enforcement, of course, we're talking about remedies. And Ines earlier said something like we shouldn't rely too heavily on fines. This is one of the few points where I agree with her. Some of you may know that I'm more in the pro-enforcement camp rather than the GAFA camp, if I may say so. Maybe fines are not are really not the way that is sort of. I mean, we probably need fines. I'm not advocating against fines here, but we should also take a closer look into structural remedies and obviously into merger control. And I think that these are two avenues. I mean, merger control, someone's pointed at this earlier, is not really developed here. I think that DMA is not the place for that, but we should look at the merger activities of the digital gatekeepers in a much better fashion. The second issue here is structural remedies. I think structural remedies, there are certain structural remedies foreseen in the DMA, but it is a very long way to achieve that. Maybe even the US is much better placed to deal with these matters. Maybe Mark can comment on that. As Ines said, I think that the remedial stage still needs a closer look, and we shouldn't rely on fines as something that really helps us in that. Now, another matter, I mean, Hendrik, you asked me, does this help competition? Will there be side effects on competition? I think there is a misunderstanding in this, and I wish to speak out on this because today, as in many discussions on the Digital Markets Act, we have a whole bunch of competition lawyers around. And as competition lawyers, I'm infected by that as well, so I'm guilty of that as well. I think that we live in an isolated island that with no connection to the rest of the legal world, I sometimes feel, in that we believe that that what we do is so extraordinary and that everything has to go according to our understanding of what good rulemaking is. I'm stressing this point because, in my view, everything in this proposal, and this is the one point where I deviate from what Andreas Mund has said, everything in this proposal points to the fact that this is regulation. This is not competition law. If this was competition law, the rules were completely different. Competition or antitrust rules are what we see in Article 101 and 102. But this is a whole set of tiny obligations that we carve out for certain undertakings. That has nothing to do with competition law. This is about regulation, and the aims are even different. Contestability, okay, you may call that competition, but fairness, one of the aims of the Act, which is there in some provisions, is something completely different. It's not about competition. And so I think that the DMA, and this is where we started from, the DMA, the DSA, the whole package, all that is about regulating the digital infrastructure that we are living in. It's time for that, no doubt about that. I think most of us are very clear on this point. And it is time to put on our regulatory ambitions in a way that is sort of a new way, because we are discussing new phenomena, or phenomena here that have not yet been dealt with in regulation before. So we shouldn't always look at this from a competition angle, saying, oh, but what about competition? What about efficiencies? This debate is much larger than efficiencies or competition. This is about value judgments in society. This is about also value judgments in markets. And this means that there is no room for an efficiency defense, because this has nothing to do with weighing efficiencies as we are used to in competition law, as we love to see it in competition law. If you move into other fields of the law, if you say, look into unfair trade practices, if you look into telling people what they are able to sell and at what time they are able to open up their stores, no one says, but that is inefficient. I can show you, I can prove with a statistical model or with an econometric model, I can prove you that it is more efficient if I open my store at 3 o'clock in the morning. Well, maybe, but we took a normative value judgment that we want stores opened or closed at certain times. And now we are taking certain value judgments, normative value judgments, that try to achieve some fairness, that try to achieve other goals in the digital regulatory sphere. And there is simply no rule to weigh the positive or negative effects in a purely economic fashion. That's competition law thinking, but we are not in the realm of competition law. And in other fields of the law, it perfectly works. If you look at unfair competition practices, I mean, I wish for more economic thinking there, but it's not as if the world broke together because you are not allowed to do certain things that, even though they may be pro-innovative or dynamic or whatever. And innovation has always been a topic in these debates. And I think that it's about steering the innovation in a certain manner, in a certain way, so that we do less depend on digital gatekeepers. I think this is important to flesh out that this is not about competition. This is about other goals that we try to achieve. Maybe these goals have not yet been debated well enough. Karel Maske pointed at this. Maybe these goals have not yet been crafted in a perfect manner in the obligations. I'm not happy with all obligations in there, maybe, or with the wording of some of these obligations. Maybe the US proposals are much better than that or not. We can debate about that. But I think the debate has to move away from our very narrow competition law focus that it has to be about efficiencies. It's a political debate. It's about achieving certain goals in the economy, and that's perfectly normal in all sort of fields that we have in other fields of the law. It's only competition law that is the odd man out with doing all these economic debates. I think one final...
okay, yeah. I just give you the chance for one final word, because I just thought I took the chance to take up this idea of an isolated island of competition lawyers and just take the boat and row towards a different island, the political one that is, and allow Andreas Schwab to step in and to tell us a little bit about the debate within the parliament, where we are at the moment, and Mr. Schwab, whether we're actually going to see a vote in the committee that's I think the week afterwards, at the end of November. Mr. Schwab, where are we heading? I don't know how long you followed the debate, whether you can actually talk about the ideas that were raised, but I think it would already help us a lot if you could tell us where the debate is within the parliament.
Yeah, thank you very much, Mr. Krafsack, and thank you so much to the Deutsche Anwaltverein for inviting me here. I have been following the comments of Professor Postsohn, and I also know what Andreas Mund normally is saying in such sort of meetings. So I can make some references to that later, but I would prefer now to speak a bit about the concrete next steps and the concrete elements on the table, so that you are most currently informed about our key topics. It's true that we have already had 7 shadows meetings. We have had several exchanges of views, and we have a very, let's say, well settled level of concerns within the DMA. And first of all, I would like to tell you that the key basics of the DMA as proposed by the European Commission have in the end not been put into question. And this is good news for this proposal, because it keeps the logics behind on the basis of what has been there at the beginning, which was maybe, and which is still not perfect, but it's under the current European law circumstances probably the best that we can get out of it. Therefore, on the enforcement part, I would like to give you some comments. I would like to speak a bit about the scope, interoperability as an issue, and the question about how profiling can create, let's say, negative targeted advertising campaigns, and what we want to do against that. And finally, I would like to speak a bit about the cooperation between the DMA and merger policy, and what is behind there. So on enforcement, you know that I was proposing at the very beginning, but not with that fixation on competition policy, but with the fixation of people with knowledge about the digital markets, that we create a enforcement structure where the application of Articles 5 and 6 can also be done at national level. Because if you have a gatekeeper that will be designed by the European Commission, and I think that can only be done once in the European Union by one regulator, then this gatekeeper has to follow some principles, and these principles might be easier to be demonstrated and to be proven under national procedural law requests in one member state to compare to another. There might be more information about a specific case in a specific country of the European Union. And to achieve this, it would have been very useful to give the chance also to national authorities, to national regulators to enforce it. But this, unfortunately, in the end, has not found enough support within the European Parliament. Most groups wanted this also to be done exclusively with the European Commission. And therefore, in the end, we have only the possibility for national competition authorities that should be part of that real enforcement structure that can go for information requests against gatekeepers, because we wanted to avoid that when national authorities go against the gatekeepers with the question of with the information request, that they are just rejected with the argument that they are not mentioned in the DMA, and the DMA in future should be the exclusive tool to go for informations with gatekeepers. And if they are not mentioned there, they cannot do anything. They will be mentioned there, so they can continue their work that they do already before under 101 and 102, and they can continue to request, but they cannot go for decisions. That is only the European Commission. And I think it's a bit regrettable because we lose a lot of capacities and resources that we could have used in this very important and very difficult and complicated task to control the gatekeepers' business behavior, their underlying platform rules and algorithmic choices that will be very, very difficult to be controlled. The second point is the scope. As we will have limited resources anyhow, with even now more when national regulators are left aside, we have to focus our work. We have to make the Commission as committed as possible, really to focus on the biggest problems. And that we can only achieve if we don't go for too large in the market and with gatekeepers. Therefore, I have been proposing 100 billion as a threshold from which onwards companies should be considered gatekeepers. Because if you have a view into Silicon Valley, and we had Ms. Hogan yesterday from former Facebook employee, we have her here, this is a battle of money. This is a battle of capital that is shareholder value orientated, and there are huge investments, and therefore we have to focus really on the top of the iceberg first, because we want to see the whole iceberg, even the part underwater. And I have been proposing 100 billions. Others have been proposing a bit less. Now we are, I hope, up to 80 billion as a compromise. And I think like that, we have the political aim of having also a so-called European gatekeeper in it, but we can nonetheless focus on the biggest problems with the biggest companies. And I think very, very much that this makes sense. It's a need, as Commissioner Vestager is always saying, better ending up with something that can work, maybe not even for every company, instead of ending up with something that is so large that it doesn't work at all. Then we have two political points that I should address here. One is the interoperability question. Obviously, the Digital Markets Act has the aim of opening up markets, and that can only be achieved if you have a clear policy to create also open markets that are interoperable between companies. But it's not the only tool that we have here, but it's one element that we should use. There is a strong political pressure that we should force the European Commission to go against gatekeeping companies to open up their APs, how they are called. There are, let's say, mixed feelings with those who follow this. I don't know if you have heard Ms. Hogan yesterday saying that on some of the companies that is even a dangerous, let's say, element, because then you have to exchange the informations, and you will have an exchange also with platforms that are coming from outside Europe, and these platforms will never respect GDPR and cyber and whatever legislation, but the data have gone once in an idea of sharing them for interoperability reasons, and they will be always kept elsewhere. So we have to think about that further, but the proposal that we are doing is quite modest, and it's a call to the European Commission to look for standards and also to use interoperability as a tool when gatekeepers' compliance is observed. The same is a bit about targeted advertising. And I think there is a bit of a confusion about words, because targeted advertising looks a bit a general issue where there is advertising the main activity. But people that speak and that are concerned about targeted advertising, they want to say with these two words that in fact they want to mean something else, which is the misuse of profiling and targeted information of users with the aim of destabilizing these people, to misuse psychological situations in lifetime of specific persons that can be traced and profiled during a platform use, and then bring to their attention specific offers that are misusing the destabilized situation. So on this issue, we have some proposal that will come up in November on political advertising, but there is also a problem that goes far beyond political advertising, and which shows a bit the risks and challenges around profiling. And we have not yet found a good way to address it in the DMA. I personally have always believed that the DMA might not be the right place to address it, but there was a strong political pressure, and we are now also speaking about that. And we try to do two things. One is to allow the European Commission to request one gatekeeper for a renew consent on the GDPR basis, showing that there might have been consents that have been given without knowing exactly what information sharing the company did. I speak especially about the Facebook case. I mean, Cambridge Analytica has not used the data from Facebook itself, but they have combined via Facebook also data with others. And there are other similar stories behind. So the Commission could come up with a new information request for users to go for a consent of data sharing on the basis of the GDPR. And that could help companies to be very careful with the data. And the other option the Commission might have is that there could also, in the compliance decision, look for some sort of specific measures that are linked to targeted advertising practices of the gatekeepers. And I know that this is a bit weird because it's very political and it doesn't really fit within the DMA, but it's topics that we had to address. The final one that I want to share with you here is the question on mergers. That is again more relevant for the DMA topics at large. And here it's obvious that the aim at the beginning has been to ban killer acquisitions. So to say, acquisitions of gatekeepers that are just there to destroy or to take over the market of a company, but not keeping the company itself, and thereby very often also losing out of innovation skills of these companies. So what we are doing now is that we create a general obligation for gatekeepers to notify, but we cannot call it notify because we want to have that approach that Professor Postsohn has been mentioning, that we should really look on it in a regulatory manner and not in a competition policy manner. We call it differently, but they have to inform the Commission and national competition authorities about all their mergers. And we want also to come up with a proposal that the European Commission on all these mergers should all the time use the exceptional competences of Article 22 of the merger regulation. So even being able to check mergers that are below the thresholds, making sure like that the gatekeepers don't buy markets, not with the aim of improving the service, but just to take over the market share. And I think there is a strong commitment of all political groups that should be an element of the Digital Markets Act. If we legally and politically can achieve this is another question that will be at the end discussed also with Council in trialogues, but it's an important political point that we should do. And I don't know if you have seen the techniques that gatekeepers apply if they cannot apply a killer acquisition. This app Futu that has been done in New York, the gatekeeper has been trying to acquire that company. But when this company didn't want to be acquired, they have just been copied the business model and have integrated into Instagram. And like that, even the strongest measure against killer acquisitions doesn't help if the companies go around and just use another technique to take over what they want. And this is Wild West approach, and that has to be stopped. And we hope that on all these practices with the DMA, that gives a very strong power to the European Commission, not only on fines, but much more importantly, on behavioral and structural remedies, that we can make a point to make markets again more balanced. That is the debate from the European Parliament. I would have liked to outline a bit more on specific legal questions that were coming across at several issues, but for time reasons, I will stop here, and I thank you so much for your attention.
Thank you, Mr. Schwab. Can you stay a couple of minutes longer, or do you have to leave immediately? Because I have one or two follow-up questions, just to be clear about what you said. Is that what you outlined more or less in line with, is that already agreed upon, or is there still uncertainty that it will be as you outlined in the end? And one follow-up question regarding targeted advertising, because you got me a little bit confused there. That's also part of the DSA, isn't it? I mean, how is that going to work out if you have that both legal acts included?
So first of all, coming back on your question in relation to, is it already agreed? I mean, as in politics, always everything can only be agreed if there is an agreement on all the points. That is not yet done, and I doubt as to whether that can be done far before the vote. But we have done very good steps to create compromises and to combine wordings that at first sight were looking contradictory, and we have to bring them into one line. Therefore, I would say that there is a lot of commitment and of common understanding that this will be our common line for the vote in the Internal Market Committee that is likely to happen the 22nd of November. But still, there might be some different points of views. My aim has always been that we should look for very large support in all political groups, and it seems to me that we are very close to this. On the question of targeted advertising, you are right that there is also a common or a similar element of concern within the Digital Services Act. But the EPP and the ECR and the Liberals, of the rather middle and right part of the European Parliament, has kept the opinion that advertising should remain something which is in the hands of the companies, that has to be lawful, and consumers and users can opt out. A bit the construction as it has been chosen by the General Data Protection Regulation. In the left and in the left part of the House, there have been several, let's say, strands appeared. Some of them wanted really to ban all targeted advertising. But this clear definition of what targeted advertisement has never been appearing, because it has never been mentioned in a way that it's only the misuse of profiling information to destabilize a person. It was rather very general all the time. And even in the left side, there were people that said, no, we cannot go for a ban. We can only go for an opt-in. And therefore, it was a bit a confusing situation where this should not have left only to the DSA, but people also wanted to see it in the DMA. And therefore, we are now a bit with a hybrid solution where there is also a part in the DMA to make sure, it came especially from the Economic and Monetary Affairs Committee, to make sure that all committees in the end will see a bit their parts in the final version of the law. But as I said, in the end, we will have to explain and to defend that all in trilogues. And I think there will be another discussions ahead of us to defend or to explain or to improve these elements.
Since Mr. Schwab cannot stay for the debate later, I would now give the chance to everybody who has a question to him to type it into the chat. And while we're waiting for that, I would ask you, Mr. Schwab, about this idea of an efficiency defense. Will this be addressed within the Parliament position? Have you tried to go for that, or was that never really debated?
I mean, we had for sure a debate about it, but the key question with the efficiency defense is all the time that if you make the process of that regulatory dialogue a negotiation where arguments from the side of the gatekeeper can be brought up against the application of the rules in 5 and 6, you risk that we fall back into the problem of the competition policy tools of the European Commission that have largely failed so far, because you give all the time the chance for the gatekeeper to go to court before a decision is done. And that definitely wanted to be avoided, not by excluding the legal possibilities to go to court, not by misusing disproportionate power to the European Commission, but making sure that these rules can really be applied without the possibility just making them creating delays by going to court. And for that reason, there has never been a deeper discussion about these defenses. In the end, it will be in the hands of the regulator, in that case, the European Commission, to assess the market and to assess the algorithmic choices of the gatekeeper that is in question, and to come up in the regulatory dialogue with a proposal how to apply Articles 5 and 6 and what the company has to do to be compliant. And I'm sure that there will be lots of reflections in such a procedure, but a concrete legal tool for the gatekeeper, as you have been mentioning, it has never been deeply considered. There was no majority for this.
All right, and since I don't see any question popping up yet, I'll just pose one last one myself, and that's about how difficult you think that negotiations with the council will be about the DMA in the end. I mean, they haven't agreed officially on a position yet, but it will be the case tomorrow if that's still, I mean, that's at least what the plan was, and there will be the final decision on the 25th of November, so 3 days after your vote. Do you think it will be possible to reach an agreement within the first half of next year, as Thierry Breton has demanded yesterday again?
Well, the Parliament is not under pressure. We are taking the time to consider all the elements that have to be considered, and we want to come up with a sound and proportionate legal proposal that is respecting the rule of law principles of the European Union. But for sure, we have the aim of applying that law not only in 2030, but as quickly as possible. Our commitment has been to vote in plenary in this year. At the moment, it looks very good. That is still our common goal. And when we, or if we can do that, then we are able also to negotiate in January and in the first months of the next year with the council. And as far as I'm in touch with the council representatives, there is a very good chance to come with common solutions and to find compromises where it's needed. In large parts, we are very close. There are some elements where we have differences. But normally the negotiations that I've done with council were all the time very clear, very precise, and very tough, because we don't want to lose time in negotiations. And I think it's the same for the French. Therefore, I'm really looking forward, and I'm confident that we can do that even before the end of March to close a deal on this.
So that means before the French election, of course. And the main stumbling blocks, from your point of view, would be which ones?
Well, I mean, it's not the key questions of the DMA, it's rather the outside questions. How much can we write in on interoperability? How tough can we be with killer acquisitions? But as I told you, the killer acquisition element is something that has to be addressed at larger level. We can ban mergers, but we cannot improve directly the world with it. And therefore, we have to balance it and to put it at large. And the final element is the targeted advertising that could be dealt with only in the DSA, that could be also dealt with in both. And we have to find a convenient solution. I would say these are the three main questions, apart from the scope where I think that we can find the level of 80 billion as a starting point for gatekeepers as a presumption to be having too much market power.
Thanks a lot. It seems
I'm thanking you. I'm sorry for leaving. Unfortunately, there are other conferences. I would be pleased to stay with you and to listen to a very interesting discussion. But thank you so much that you have been allowing me for that time here. Thank you.
Thank you. And before we turn to the discussion, I would suggest we're running a little bit late, so we're not having a full 15-minute break as is foreseen within the program, but I would suggest we take at least about 10-minute break to 5 minutes to 4, that everybody can just catch a little bit of air and then breathe a little bit. And afterwards, I'll do invite you to participate in the debate as much as possible. I want to keep that as interactive as possible, although I'm aware that we've touched upon so many different issues that it will be rather difficult. Thanks a lot, and see you in 10 minutes. Enforcer of the DMA is the Commission approach.
Yeah, it's related to 2 points that were made throughout the debate. The first is really the focus of the DMA, which also for us is very important, to really zoom in on only the largest gatekeepers, which by definition also have activities throughout the European Union. And secondly, what I emphasized in my introduction, the internal market dimension of the Digital Markets Act and the wish to come up with rules that are uniform across the EU and are also enforced in a way that is uniform. So that quite naturally led us to propose a system of a single centralized enforcer. But that, of course, by no means means that we would not be with two hands grabbing also the added capacity and knowledge that is available in the first place, indeed, in national competition authorities, which are working with rules that are quite similar. So we have always been saying that when it comes to being our eyes and ears on the ground in order to detect, for example, issues in the market, or to receive, for example, complaints by business users about behavior, that we would very much use this informal coordination mechanism that we have between the Commission and national competition authorities to see what exactly are the facts on the ground, what is the best tool, or are the best tools to deal with it. So in that sense, I would see the role of the Commission as less exclusive. If I can also pick in here on a point that was made by Professor Potstun on private enforcement, because to me as well, it was shocking that a bar association pleads for EU law not being applied by national courts. Of course, if you have contractual provisions where the national court is asked to apply and which are contrary to the DMA, it's only a matter of very basic European law that the European law must there be applied and have priority over even national provisions. So in that sense, also the role of the Commission as public enforcer, as the authority imposing fines, is unique. But that doesn't mean that it's not helped in that enforcement also by national competition authorities and by national courts. So I heard a lot of convergence, I think, on a number of issues, but I wanted to highlight at this point about the focus and the importance of enforcement here.
Mr. Mund, is that, from your point of view, enough? I mean, it sounds to me like we have this cooperation, the ECN, the network. We already spoke about that, but as Mr. Potstun said as well, the Commission cannot do that on its own, particularly not if the scope is wider than the one foreseen in the United States, at least. From your point of view, is the Commission simply not seeing the added value you could offer, or are you not seeing what you actually can offer and the Commission is willing to take from your side?
No, I'm pretty sure that the Commission is aware of what we could add to this. I think we struggle here with a very fundamental and structural problem. We have discussed at length, is it regulation or is it competition law? And why should it be regulation? Well, it contains a certain number of do's and don'ts, but it does not contain a general clause, which is different from the German approach in Article 19a, which has a general clause. So I had a company here yesterday who complained about a couple of new strategies they see that might give more power to big tech, especially in the internet. And we asked them, does the DMA help you in this respect? And it said, well, this is all new and it doesn't really fit under many formulations we see in Article 5, Article 6. I mean, this is something we would take up with Article 19a with our general clause. But if it contains such a general clause, then everyone here on the panel would probably say, well, if it contains a general clause, then it's competition law, because it's not regulating anymore, it's not ex ante anymore, then you have to investigate, then you have to find out what is at stake. And I think this is something we have not really found a clue to yet, because if you say from the EU perspective, this is regulation, and then I understand to a certain degree that should be focused on the Commission. On the other hand, if you would say this is competition law to a larger extent, then you would say, then why not do it in the framework of the ECN? So what I'm very much afraid of, that in the very end, the DMA is in place, the Commission is confronted with lots of new strategies. I mean, this world is really developing fast, extremely fast. And what was new yesterday is stone old today. And if you don't handle that properly, then you run into difficulties. And this is where I see the difficulty of the DMA approach. I see the effort to do it as precise as possible, to make clear this is ex ante and this is regulation. But that means at the same time that it is crystal clear on what is prohibited and what is not prohibited. But then the companies we're talking about, they will invent lots of strategies to do something else with the same aim. And you won't find a word on that conduct in the DMA. And I think this is the debate that we have, which has also a lot to do with who is in charge of dealing with these kind of issues. And if you constantly have a new conduct before your eyes, and this is exactly why I believe that our Article 19A is more future-proof in a certain manner, the more you have to deal with new strategies, with a new conduct and all these kind of things. The representative from Shopify might have a word on that, how fast that goes. The more you talk about it, the more you come to the consequence, well, you cannot really regulate it in a certain sense. It's always a bit investigating about assessing new conducts. And since, as long as we are not clear about it, what is this about? Can we do it exactly the way the Commission has proposed it in the DMA? As long as this is so, I think we will also discuss who's going to enforce it. That's part of the problem from my perception.
So what you're basically saying is it's either clear-cut regulation, then it doesn't do any good because it's not future-proof, or it's competition law. Is that?
No, it's not. It's not going to do any good. Of course, it is going to do good, but I am absolutely sure there will be new conduct that will be very, very fast in place because companies know about the DMA, and I'm pretty sure there are already strategies in these big companies how to circumvent the do's and don'ts in the DMA. I think this is already happening, you see. So this is why this is so complicated, and this is why I believe we might run into an enforcement bottleneck. It has to. There's lots of good things about the DMA, but we have to think it through to the very end. This is my point.
Mr. Neefer, Ms. Bennett, you can react to that a little bit later, because I would like to hear the US perspective on that. Because I mean, the bills you were mentioning are working with do's and don'ts, mainly don'ts, rather don'ts than do's as well. I mean, do you see this problem of creating a regulation that is not future-proof enough, and so in the end can be, maybe not easily, but can be circumvented?
Yes. This is always a problem, I think, whenever you're defining legal rules clearly and concisely versus using general standards. There's always the risk of over-inclusion or under-inclusion. There's always a risk of a failure to anticipate future behaviors when you define clear-cut rules with clear-cut do's and don'ts. Setting aside whether the DMA is regulation or law enforcement, those issues arise in either setting. And so I think there is a risk that the more concise, the more precise are the list of do's and don'ts, perhaps the more likely it is that gatekeepers may be able to devise strategies to get around those clear prohibitions. On the other hand, of course, a clear list of do's and don'ts provides substantial guidance to businesses, and that can be of benefit as well. So there really is sort of a balance of pros and cons to taking the strict, concise, clearly defined rules approach versus a broader standards approach. I will say that in the United States, the legislation I identified takes place or is placed within traditional competition law enforcement protocols. The legislation will be enforced as the antitrust agencies enforce their existing antitrust laws. So this will involve a process of going to court if the agencies believe there's been a violation of the laws. This will involve the process of potentially judicial review of decisions made by the FTC, by the Department of Justice. And so that, of course, is a much slower process than I think the proponents of the DMA may believe is appropriate, and hence motivates the DMA to a certain extent. So, you know, I think Mr. Munt raises a number of good points about the possibility that a clearly defined list of do's and don'ts perhaps may invite folks, gatekeepers, to think about ways to get around those clear rules. And I'll stop there.
Okay, Mr. Rodriguez, I don't know whether you would like to step in, because I would really be interested to hear what you think on this debate, and whether you share the point of view of your colleague, Mr. Pachun, that this is clearly not competition law but regulation, and what future-proofness this regulation actually needs.
Thank you very much. I completely agree that it is not clear what is the regulatory or the strategy behind the DMA. However, I like to see precisely in this effort of the DMA process not to be clearly a competition law product. So I see that there is some element that try to at least be in a midway. Be anticipated to the traditional logic and the traditional philosophy, and therefore the tools and instrument that a competition law apply. And that is very important because it's probably producing a hybrid strategy, in the sense that the goals, the policy goals, are not the one that we traditionally associate to competition law. I agree as well, Mr. Mund was very clear in that regard, that they are open-ended concepts that apparently that not allow us to define as a proper regulation, but in my opinion is a hybrid regulatory strategy where the scope of application and the final definition of the obligation are subject to a dialogue between the market player and the authority. And that is, in my opinion, innovative, has merits at the same time as drawbacks and some risk. But it is not a proper competition law. Otherwise, we have a lot of criticism to do to make to the DMA. It's not competition law. Probably is not a proper regulation. It's a hybrid model, and therefore merits and some drawback are converging in this new strategy. Thank you very much.
Mr. Pachun, do you think, just listening to what Mr. Mund mainly said, this regulation is future-proof enough? Because, I mean, of course, we see Article 5 and 6, and we can just pretty much say this is case A, B, C, D, or rather Microsoft, Facebook, Google, etc. And this is all just fueled from cases we had or that are still ongoing, but that doesn't mean that we find any solution for new ideas, something that's coming up new. So wouldn't we need something like a catch-all clause within, or some future-proof, open formulation? I don't know how to phrase it.
I think we should pay credit first to the European Commission, because they tried to integrate an updating clause in the DMA, which sort of allows for some amendments. That is a burdensome process. I don't know exactly how that will carry with delegated acts, etc. But at least they've seen the problem. I think we should be clear about that, and there is a certain mechanism to amend the DMA. I think the other point is that we have competition law. We have all sorts of other regulatory tools. We have the DSA. All this remains intact. So when we find out that there is other behavior, we are not sort of in nowhere land, but we have the Bundeskartellamt, for instance, that can step in, do a 102 case or normal competition case. I think that will still be possible, and even I think the Commission does not doubt that there will be some. Mr. Mund, I hope you agree, or Inge Berners, I hope you agree. That's probably more important.
Just saying, in 5 years' time or so, we will be done already. I mean, this is about speeding up. I mean, sorry.
Yeah, but that's exactly the point that I wanted to make. I think that the criticism of the DMA, or parts of the criticism of the DMA, I mean, we all agree this is probably not future-proof, and we will see other behavior coming up, etc. But this is now a step where, at the present time, we decided in favor of a certain regulatory instrument with what we see as self-executive rules, self-executing rules, or something like that. So we try this now at 2021 or 2022, and then there will be further steps and search processes going on. And of course, we need to amend that all the time. The problem is more the burdensome procedures of European lawmaking, probably, rather than the real problem with the DMA, because I think a general clause is something that we have in competition law. Then the competition people need to amend their procedures so that they are speeding up.
Mr. McGuire, how much trust do you have in that? I mean, Mr. Nefer just mentioned you or was it Mr. Moon? I'm not sure that you could probably talk about new ideas to hinder or to block competition. Maybe you could enlighten us a little bit and talk a little bit about your experience when it comes to that.
Sure. And so I think that's right. I think the risks with the DMA and the ex ante approach are you inadvertently hinder the innovation you want to see in the contestable market because the requirements don't map perfectly well onto all of the different business models and all the way people innovate. And that's why, we do favor sort of the regulatory dialogue and having a chance to talk to Mr. Muntz or people at the commission if you are covered, to say, here's what we're actually doing, and work in good faith to understand what the harms are that are being seen and sort of understand the best way to apply the obligations. Early on in the process, we talked often about how most things to us felt like they fit in Article 6, the idea that it's all sort of gray. And it would make sense to kind of talk through these issues. I recognize some of the concerns expressed from the regulatory community, which is essentially companies are looking for ways to get around the rules and not comply. And I think that's why I sort of highlighted in my remarks, and what I'll highlight here is this good faith idea. And I think it runs in both directions, where companies can feel like they can be transparent and come forward and explain how things work and understand what the regulatory community is worried about. And sort of on this flip side is eventually hopefully having trust from the regulatory community that companies will act in good faith. And how you design that process is difficult. But that is, I think if you wanted to have a future-proof regulation, it is that dialogue, that ability to iterate as the environment changes very quickly. Because Shopify's growth has been explosive through the pandemic and offers, whatever services we can think of that an entrepreneur would need. It's intentionally innovative to try to capture all of the nuance for what a small business might need to succeed in a global marketplace, which does mean it changes quite a bit.
It seems that we lost Mr. Musk, if I'm not mistaken. At least I don't see him on the screen. But Ms. Bodenstein, I saw you nodding a couple of times. You're still there. That's yes. Good to know. So I can bring you in as well later on. Ms. Bodenstein, I mean, from your point of view, to be a little bit unfair maybe, or blunt, or I don't know how to say that. Are you already working on ways to circumvent what we have in Article 5 and 6? You'll probably not tell us anyway, but how do you see this whole debate from the outsider perspective? That's not a real outsider, but I stop here.
Thank you. Let's take it from the outsider perspective, indeed. And I think what we see here seems to be a battle or a competition of systems. Either we have regulation that I think cannot be future-proof in itself because it's regulating a current status according to our current knowledge, and it can only be future-proof by adapting or modifying the law, which, as Mr. Potzun rightly say, it's a really complicated process under European proceedings. And competition law can be more future-proof just from their mechanics. We have a general clause. It can be adapted to future needs. So what is more favorable in this regard, the DMA approach or the approach of the 19A that we are seeing in the German competition law? And from the outset, I would have said, always taking the perspective of the outside counsel who learns about different business models, new ideas, how to frame the products, how to modify new products that are out there. And from an outside counsel perspective, I would have preferred a concise list of do's and don'ts. It's easy to comply with such a concise list. You can give clear guidance on how to shape business models or code future products. But the DMA, as it is now, it's unfortunately not such concise list of do's and don'ts. There are very broad clauses in there, and you will be really struggling if you have both. Besides the new business model that you have to assess, and then the list of the DMA provisions, you will really struggle with these provisions. And so now I know I argued a lot against Section 19A, but I have to admit now it might have a better approach to tackle with these future business models by saying we have a general clause. It might be broad, but we have an efficiency defense for you undertaking. You can tell us why you think it's efficient what you're doing here, and we will only prohibit the conduct for the future. And so having now both the DMA draft and the Section 19A next to each other, I think Section 19A might be better suited and future-proof.
Which brings me, of course, Mr. Mondo, okay, do you want to step in?
One sentence. We have an efficiency defense, but the burden of proof for that efficiency defense is not, as usually in cartel law, in competition law, on the agency, it's on the company. So they have to prove, which is, from my perspective, a real game changer, and which might help us to be much speedier as well in the future. It's not up to us to prove that.
Which now brings me back to you, Ms. Barnett. First of all, is the process of delegated acts to adapt the legislation really, from your point of view, that difficult, or is it actually a good way to take new developments on board? Another question that came up earlier in the chat, just to be 100% clear about that, once the Commission identified a company as gatekeeper, can the Bundeskartellamt still apply 19A or not? Just to be totally clear about that.
Yeah, thank you very much. I must say I agree with a lot that has been said on the point on the interplay and the advantages of the DMA with specific rules versus then more generic clauses that are looked into then also on the basis of a more detailed analysis into effects and efficiencies. I think that's precisely why the DMA for us is complementary. Yeah? I like this idea about the tip of the iceberg where it focuses on the well-known problems by the biggest players. And yes, there will always be attempts to anti-circumvent. It's not that we by default have an idea that industry will circumvent, but it's unfortunately a little bit also the experience that we've had through the antitrust enforcement, that you see the same type of problems popping up again and again and again. So in that sense, the DMA does have an anti-circumvention clause. And in this context, it's also relevant to refer to the regulatory dialogue. Because as Mr. Maske was saying before, the regulatory dialogue is there not only to the benefit of the gatekeepers to, in a dialogue with them, specify the implementation modalities, but also in a dialogue with third parties to avoid that gatekeepers can circumvent the provisions by specifying the modalities in a decision based on that regulatory dialogue. And then there is the instrument that you asked me about on the delegated act. And now reference is being made to the legislative process being a heavy process. I think that's correct. It's a legislative process where the co-legislators get involved. On the other hand, I think if you see the diligence with which and the expedience with which now also the Digital Market Act is being developed, it doesn't necessarily take years and years and years in order to adopt a law to start with, and certainly not to amend it if we see a clear hole in the system. And likewise for the delegated acts, it's a faster procedure where the Commission tables a proposal, and that's then through comitology procedure made binding upon market participants, which also, I mean, it's not something that can be done overnight, but we know in urgent cases, and again, the financial crisis, the COVID crisis, we've seen a couple of instances where if really there is a lot of political will and there is an urgency, such acts can also be adopted quite speedily. So altogether, the DMA focusing on this narrow known problems by very large gatekeepers with some anti-circumvention clauses, with the possibility to update through delegated acts, and importantly, with competition law enforcement to indeed deal with the large part of the iceberg that is under the water, and that then can also influence and inform us on future updates of the DMA, is, I think, a holistic system where the different tools in the toolbox have different characteristics and can be used in a complementary way.
And you don't see the risk that we're actually running into a Microsoft-like update system where we have a new update every couple of months because there's a new idea coming up by the gatekeeper to block competition?
Whether it will be every month, I think that would be a bit fast. But also, if I look back at, again, the case law and antitrust over the past 20 years, it's still the same operating systems and so on coming back in the same type of behavior. So although there is a lot of technological evolution, and although one shouldn't be naive about potential of circumventions and new issues popping up, I think one should also take that with some degree of distance, and that in a couple of years' time there will be a DMA version 2.0. I think I also have not much doubt about that. Likewise, that's what we have seen in telecoms regulation and energy regulation, that you have different versions of a regulatory framework that each time adjust and adapt to new developments. By the way, that's true also for competition law instruments of secondary level.
And Article 19A and
on 19A and the DMA, for sure, there is a lot of room for complementary enforcement of both the Digital Markets Act and both EU and national competition law. So it's not that once the DMA is up and running, that there is no room anymore for the enforcement of 19A. Of course, it will be important there too to coordinate, to make sure that outcomes are consistent. And there is a certain degree of limitation to the extent that 19A cannot be used to go against the DMA. There again, the internal market objective holds firm that within the scope of the DMA ensures the full harmonization of regulatory action in this field. But as said, again, there is plenty of scope for enforcement of Article 19A, of competition rules, in addition and beyond to the DMA.
You mentioned the tip of the iceberg, which brings me back to the question of scope. Mr. Neefer, one of the points that were always made within the debate within the European Union was that the wide scope was chosen by the Commission also to avoid the impression that they are only going against American companies. Whereas you were actually, if I take you for the American side, are going for this 4 or 5 companies you mentioned before. Would that have been really a problem if the EU would have just gone for the GAFA plus Microsoft companies?
You raise a point that, of course, well, first off, I should say that I have no idea what was in the mind of the folks that put together the DMA. I prefer to debate the merits and demerits of the DMA in terms of its effect on competition, in terms of its effects on whatever social goals it seeks to address. And whether or not the DMA is limited to US companies or some broader group doesn't really concern me as much as whether the legislation is effective, whether it serves the goals it seeks to serve, whether it does so appropriately and as efficiently as possible.
That was a very diplomatic answer, but thanks for that anyway. Ms. Barrett, why did you go for this broad approach? Because I mean, when you listen to the ones arguing that when you take into account that you probably have 80 commission officials working on a DMA, that if you go for more than 4 or 5 companies, it would be simply impossible to deal with that. And it's right to assume that they will just, as I don't know, one of the speakers said before, just simply say, we are compliant, prove us wrong. And can you actually do that with the capacities you have when you go for such a wide scope?
Well, first of all, I don't know on what basis you consider that we go for a very wide scope. I think if you look at the quantitative criteria in the first place for the designation of gatekeepers, I mean, they are set pretty high. And as was said before, also the list of core platform services is a closed list. So if you look at our impact assessment, I think we assessed at the time that we would have between 10 and 15 companies in scope on the basis of the quantitative criteria. I mean, to be seen, we've heard from Mr. Schwab that there is a discussion, at least in Parliament, to increase the thresholds further. So I wouldn't say that really the DMA targets such a large group of companies. I think it pretty much zooms in on a limited number of companies. And again, as Mr. Nieve said, whether those meeting the criteria are then American, European, or Chinese companies doesn't matter. It's really their size and their position as gatekeepers on the EU market that matter. So, of course, on the basis of qualitative criteria, we can designate more gatekeepers. And I guess there is a certain dimension of making sure here that we are future-proof, which has come into the DMA also on this aspect, that we are able to, for example, already act when a company is not an entrenched gatekeeper yet, but that we are able to designate also emerging gatekeepers under the DMA. But what needs to be highlighted is that the process for doing so is, of course, a different one, and that's done then on the basis of a more detailed market investigation. And then is the case for the first tier designation of gatekeepers on the basis of the qualitative criteria. So, I mean, to put it short, in my view, also the scope of the DMA in terms of number of companies affected remains highly narrow and in that sense limited to really the biggest gatekeepers on the EU market.
So that would mean that this whole debate we had about the thresholds was mainly misleading or not actually down to the point.
No, I think that the question about thresholds is not misleading. It's a relevant one, but I think both with the thresholds that were put in the initial Commission proposal and even more so with the thresholds that are being discussed in the European Parliament, the circle of the number of companies that would be caught by these gatekeepers is quite limited. And again, you'll find the detail on that in our impact assessment that accompanied the proposal, referring to between 10 and 15 companies that would be caused by those thresholds.
Mr. Maske, to bring you in, this idea about a service-based approach versus a provider-based approach, Ms. Rodriguez brought up. How does that sound to you? Because it seemed, from my point of view, rather just fitting to what you actually said or complained about with regard to the DMA.
Yeah, we are facing a fundamental problem with the DMA. It was set up to solve specific problems where we thought we have some solution. But then it went further than that. It didn't stop in regulating the problems we know. But this smokescreen of future-proof, I think, completely derailed the discussion. And the discussion where it currently stands, where it's a lot around future-proof and the cases we don't catch, as opposed to talking about the cases we want to catch and where we need to act and where we need to act differently because our current tools are not sufficient to deal with these problems. So the DMA become the classic example of the perfect becoming the enemy of the good by broadening out these solutions we know for specific problems to everything digital, just because a gatekeeper is involved, is just the wrong approach. Because it makes sense in a specific context, but it doesn't make the same sense and doesn't have the same justification in the other context. And then you can think about, after solving all the problems that the DMA is identifying, what the rest of that is. Yeah, there will be problems, but maybe competition law is still sufficiently capable of dealing at least of some of these problems. And then indeed, the DMA provides for a solution for that. So what I would argue, let's deal with the problems we have on the table. There is a new toolkit which allows to do that, and make sure that we are not getting ahead of ourselves by thinking of broadening it and then creating all the problems we have. Of course, we are thinking about how we need to apply the DMA. We have 200 cloud services that are probably in scope. How you apply 18 provisions which are not made for these cloud services to these 200 different cloud services? How should we effectively do that? How do I effectively advise Microsoft on what they should be doing or not doing? I won't be capable of doing that. There will be hundreds of lawyers working on this, trying to make that work. And what do? We just create red tape. We are not creating solutions. Let's focus narrowly on the cases which are problems where we have solutions. The DMA is providing some solutions. Let's discuss them, make them clear enough that they can be applied, and put the competition authorities, whoever that may be, in a position with the right procedure to find the solutions that are necessary and hold the companies accountable. That's what we are arguing throughout this process. It's not very popular. We are called of dragging our feet. We want enforcement of this, but we want it in the right cases. And we don't want to be caught in discussions with regulators and before national courts and wherever around practices which someone thinks they are problematic and we think they aren't, and we can't do anything about it. We want to have solutions and comply with those solutions rather than having all this litigation, even though it will keep us busy for at least up to my retirement.
We're going to come to dragging our feet a little bit later, but Mr. Mund, what do you think about this approach, the different one that was proposed about focusing on service-based rather than provider-based, an approach that is service-based rather than provider-based?
I'm not so sure that. I mean, that is difficult to think through, but you might be confronted quickly with similar problems than we are, that are not so different from the problems that we are confronted with right now. So I think that is a difficult point. I mean, the point that I see is, I mentioned that already, how far, especially at this moment, the digital economy is about to change. I mean, if you look at this, there's really something going on. Very difficult to understand sometimes from a technical point of view. What are they doing here? What does it mean? What is happening? And sometimes a minor change in an algorithm has a huge impact on everything that is happening at a different place, which we do not, which is difficult to see beforehand. This is my point, and we haven't quite found a solution yet for that. By the way, of course, it is always very ambitious to find a regulatory solution for different companies with completely different business models. I mean, the business models of these companies, they are so different. We see that already right now in our proceeding under Article 19A, where we have to designate certain companies to be companies of significant importance for, or of significant importance for competition across markets. And we see, however, every company is different. The reasoning is always different. The conduct, how they get there, is different. It's different services. It's a different combination of different services of these companies. In the case of Amazon, it might work completely different from Facebook, you see, and to take that under one headline, no matter if you take it as a provider or as a service, I think it always creates the same kind of problem here. So I do not really believe this is a solution, but I'm worried about how fast this is developing at the time, and if we as agencies will really be able to catch that in due time. I mean, there might be a mechanism to add new conduct to the DMA, but I remind you that is then a per se conduct, that we as a competition agency have to identify clearly as a conduct that has a certain effect on the market, and because of that negative effect, it is per se forbidden to all of these companies to do that. To be frank, this is everything but trivial. This is really a complex exercise. So it might go fast once you have taken the decision to include a certain conduct into the DMA, that might go fast, but to identify this conduct and to say this is prohibited per se. I mean, what you find in the DMA is the quintessence on what we have done over the last 10 years in Europe and in the US to a certain extent. I mean, that was an easy task, if you want, because we had so many cases, some of them even confirmed by national courts, some not. But the future, this is my point, is completely different. And this is why this is so worrisome for me, because once the DMA and 19A is in place, it's not going to be changed in very fast time. So we have this shot, and it must be right. And this is why I believe we need all the experience that we have in Europe. You will need my economists here. You will need my technical people in order to do it right, and we need the Commission. So this can only be a success together. I'm absolutely sure. I mean, I always find examples from the old offline world. We have just implemented here the so-called UTP directive for the relationship between producers and big food retailers. I mean, there it is said crystal clear that a deadline for paying for goods may not exceed 30 days. You can compare that to the DMA. Of course, Edeka or Rewe will never ever write into a contract, I only pay after 35 days. I mean, that would be quite obvious that this is against the law. But I promise you, they will find another way to come to the same goal. That's my point. And this is what makes it so difficult. And this is the differentiation of service and provider. I do not think this will change anything. By the way, I did not want to accuse Rewe or Edeka of anything here. It's just
that's noted.
It's just an example. No. You know, it's just an example.
That's noted. Just to be fair, Ms. Rodriguez, just because your idea doesn't really seem to find too much support here. Do you want to defend it once again for just shortly, or because I think it has there are certain merits to that, because otherwise when you talk about the providers, it's always against Google, it's against the evil companies versus the good ones, and so if you want to,
Yes.
you can defend it once again, just to give you a chance.
Absolutely. Yes, very happy to discuss, and I'm very happy to see to which extent is a good approach or not. A provider-based approach has, in my opinion, the risk of capturing big companies, even if they are not platform companies, in the sense that they are big companies out of the platform business. They use this position in order to start providing new purely core platform services, and suddenly, because of their existing size and magnitude, become immediately within the threshold and the condition that already the DMA set out. However, we don't want simply to go against big companies because they are big. We want to identify certain services, the core platform services, when they create a gatekeeping potential, a gatekeeping risk, because of that particular core platform services. That is the reason why I believe that in the application of the criteria, in particular in this phase, a service-based approach is, in my opinion, achieving better achieving indeed the policy goals. It is not capturing simply a particular player because it's big. It's because being big, in a very general way, is providing those kind of services that the DMA want to address. That would be, I hope, that a better explanation of my idea.
Ms. Burns, I see you thinking. Yeah, I would just go ahead.
Yeah, thank you very much, because maybe I can also clarify a bit in this regard, because I think also in this aspect, the DMA is a hybrid. I think this was a term used by Teresa before in another context, but I think also in this sense, in looking both at the company level and at the services level, the designation criteria are a hybrid. This is because we observed in our analysis that, of course, the conglomerate nature and the size of the conglomerate in itself has also an impact on the economic power that it can leverage towards users and business users. And that's why the first set of criteria look at the turnover and the market value of the company. But the second set of criteria on users and business users are really service specific. And the designation will always be specific for a company on a given core platform service for which they hold that gatekeeper position. So in that sense, that can maybe reassure a little bit that the integration of the service perspective is certainly there in the DMA proposal. And the obligations of Articles 5 and 6 will, of course, apply only to the core platform service for which that company is designated a gatekeeper. They do not apply to other services of the conglomerate. That's also an important element of proportionality of my view.
Thanks for that clarification. And Ms. Bodenstein, which brings me back to dragging our feet, as Mr. Muske phrased it before. No, I just wanted to come back to the point of the regulatory dialogue, the efficiency defense, etc., the points you made, because Mr. Schwab was quite clear about that, saying basically that's only because the companies want to prolong the process as long as possible, and it's only to make it as difficult as possible to apply, and that's the only interest, and that's why we didn't pick that up. I assume you wouldn't agree with that.
Yeah, sure. I don't agree that it's only about prolonging the process or being as difficult as possible in these contexts. The background is that the conduct is not to assess as easy as maybe discussed here. It's not black and white. It's always a gray picture. And now, after years of antitrust proceedings, we can say that now we know that self-preferencing, it's a pending proceeding, that self-preferencing might not be good for a gatekeeper, that wide parity clauses are not good in this context. We know these after years of antitrust proceedings, after having assessed all the individual circumstances of these cases, having thought about pro-competitive aspects, having thought about anti-competitive aspects, and now this can be the underlying basis for these provisions in Article 5 and Article 6 of the DMA. These are the more clear forms of conduct for which the regulation might now be the right place and point in time. But for these other conducts products that we are seeing there. And maybe indeed this the Amazon clause might be a good example here. It's not so clear cut for these other kinds of clauses. It's the Article 6A. So you're not allowed to use any information that you get from business user activity on your platform for competitive reasons with these business users. So there's a clear notion to this form of conduct. Don't take the pricing information of the retailers on your platform and undercut their prices with your own products. It's a clear core to this provision. But on the boundaries next to this, it's not as clear cut not at all. There are many other kinds of information that can be derived from business users. The traffic they are using, click time, conversion rate. And so there's many information that you can gather as a platform, and it's not so clear how you can or should use it for your platform. You can use it to improve your platform services. And so here we are on the boundaries where we are very much in the gray zone, where we have to debate why do you need this information, how do you use it, in what cases, when don't you use it. And these are the things that we have to discuss, and we need a place to discuss it. And either we do it in the regulatory dialogue, or we do it in efficiency defense, or for certain of these provisions in Article 6, actually an efficiency defense is already worded into the provision itself. We have some broad wording like duly justified, proportionate, undue, and then we would have to read these efficiency considerations into such terms. So it's absolutely not about making the process too slow to ever be effective, but to discuss the real aspects that need to be discussed for these types of conduct.
Mr. Potsun, how do you see that? I mean, because you not hear that from Mr. Schwab, of course, but from lots of different, mainly parliamentarians, that this is seriously or mainly really about making the process more difficult and doesn't make any sense at all from their point of view, that is.
Well, I think there are 2 points in this that I would wish to mention. The one is, I think we do not really have real clarity about the goals that we wish to achieve with the DMA. I think we have to be frank in saying that. The Commission says this is about contestability and fairness, and then there are a couple of sort of very detailed provisions, or detailed, maybe not detailed enough for application, but we are not really clear about the picture. What do we expect from the digital economy, from digital gatekeepers to deliver? Say, if you take a term like interoperability, someone mentioned that earlier. Is that something where we say interoperability should be there generally or not? I think these are the questions that we should answer. And if you look into the DMA, there is a provision on interoperability that is sort of very, very, I think in 6C or something, which is very neat and applies to a certain group of companies, etc. And that makes it so difficult to interpret these rules. And that's something I think that bothers some people, in the sense that, I mean, we're used to interpreting vague rules. But if we are doing that, we wish to have some guidance or something like that, and this guidance is missing because there are no overarching principles, but these very, very abstract principles of contestability and fairness. The second point is, Mr. Musker earlier said, now we'll be working for years with hundreds of lawyers on this. I think the reason for that is basically that, okay, there is now one heavy package coming because we haven't regulated enough in the past 20 years. We have simply kept it going. And now these companies grew to enormous size, to enormous power, and enormous influence on markets. And obviously we wish to deal with them now. I think that's the price we have to pay for letting them grow for 20 years in a largely unregulated fashion. That now sort of there's such a huge package coming and a search procedure that's maybe starting 10 years too late.
Which brings me to the structural remedies you mentioned earlier. I didn't want to bring that up earlier because that has the potential to hijack a whole debate. But it seemed to me that you're a little bit, that you would have wished for a little bit more teeth when it comes to that within the DMA. I mean, we know that within the Commission, there were different schools. There was Vestager on the one side, who was quite hesitant, and Breton, who wanted to go further. Do you think that that's a missed opportunity?
I'm not sure. Maybe you can give that question to Mark Niefer. I think he's perfectly
He would have been
qualified.
the next anyway on my list, so we'll go right away to you, Mr. Niefer. I mean, Mr. Butson said it's probably more likely that we'll see that approach from the United States coming. We all know that the US has been less hesitant, well, at least when it came to a certain point, when it comes to structural remedies. What do you think about that?
So I can speak to proposed U.S. legislation and how that compares to the DMA. My understanding is that the DMA allows for structural remedies only in very limited circumstances, and in particular when a gatekeeper has been sort of a persistent or systematic violator of the DMA. In the U.S., there has been proposed legislation, I referred to it briefly, that would call for structural remedies in the case of a firm that owned, in the case of a covered platform, that owned a business that created certain conflicts of interest. You know, I won't speculate on the likelihood that that legislation will be enacted, but it is an extreme remedy, I would think. In terms of law enforcement efforts, of course, structural remedies in a non-merger setting have been rare, and the experience is that they've been difficult to implement. I would think that that experience would bear on any attempt to impose structural remedies on gatekeepers or on covered platforms. So that's all a long way of saying I have no idea how likely such remedies would be in the case of either legislation or law enforcement. And I'll stop there.
Okay, fair enough. Does anyone want to come in on that from the other panelists? Apparently not. I wouldn't have expected.
If you give me the floor again, even though I dismissed it a second ago, I think that what Mark Niefer said, I mean, it's hard to imagine that the European Commission steps forward and says, Amazon, now we separate you into certain on a horizontal basis, or Google, you have to get rid of some services also. I simply cannot really imagine that. So I think that is not a debate that we should take too far. And I'm pretty sure that most of these companies will be able to avoid this being the systematic law-breaking gatekeeper. But interoperability would be something like a remedy that may achieve something in the same vein, like breaking up companies, and maybe much easier regulatory tool.
Ms. Barrett, do you want to step in there? And I'm not referring so much to the structural remedies, because I know that will be difficult to talk about for you. But the interoperability, I hate this word, question that Mr. Schwab as well brought up. I mean, would have that been a good way to deal with problems we see with platforms and gatekeepers? Because as Mr. Butson said before, I mean, we see that within Article 6, but only in a very limited manner.
Yeah, indeed. I think, again, this testifies to the point that the provisions in Article 5 and 6 are often, when you look at it in detail, drafted in a more precise manner than sometimes the way it is portrayed in the public debate. On interoperability, it's a term that covers several meanings. So I think we need to be a bit more precise on what is meant. Do we mean interoperability in the traditional sense also of the electronic communications framework of letting one end user reach the other end user through communication means? That's often referred to in the context also of social networks, whether the DMA should impose the interoperability of social networks from that sense. And I've been reading also that Bundeskartellamt has been doing a form of sector inquiry, if I understand it correctly, also into this question of interoperability, which also indicates that there may be pros and cons, so that one should not jump too quickly to those type of decisions. Another question and another meaning that often interoperability is used for is more access type of regulation and granting access, for example, to core platform services in order to develop competition on ancillary services. And there you will indeed find in the DMA some specific provisions that do indeed, when it comes to operating systems, for example, grant fairly far-reaching access rights there in order to promote precisely this competition also when it comes to ancillary services. So I think when it comes to the term interoperability, one needs to pause a bit and discuss in a bit more detail what is meant, because I have the feeling that it's used in very different senses. And some ideas, I think, may be more directly suited also to be addressed in the Digital Markets Act than other meanings of interoperability, for which other frameworks may be better suited.
Of course, although I thought we meant it in the way that we're not talking about sending a message from Signal to WhatsApp, but in the second manner you mentioned. But since we're getting close to 5 o'clock, we'll stop here. We only scratched at the surface, as always. I mean, that's the case when you have so many panelists with so many different but very interesting points they're raised, and then you have unfortunately always just 1 hour to debate about that. So thanks to you all for your participation. Thanks to you all for your contributions. And I will just now simply hand over to Jürgen Werner from the Bar Association, the German one, for some final words and shut up and leave you be. Thanks a lot. Mr. Werner, I don't know whether we have a connection problem here, but there seems to be something not working. So in this case, and I'm speaking slowly just to give him the chance to step in. All right, okay, if there seems to be a problem, so then just I'll just thank everybody for listening, everybody for participating, and wish you all a very good evening. And it's 5 o'clock sharp. We'll stop here. Goodbye.
Thanks, everyone.
Hey, thanks. Goodbye.
Thank you. Bye-bye.